Hello, everyone. Good morning. Voice is cracking a little bit. Hope everyone's having a good morning. I just woke up, as you can tell. And I said to myself, well, I need to do two things. Laundry, which is currently being done in the background, and some bar exam. I got two things. Laundry and bar exam. And a lot of laundry. How y'all doing? Good morning. We're just going to chill here for a second and hang out for no particular reason as people join. Hang out. How's everyone doing? R. Fulmer, good morning. Secret McSquirrel, glad to have you here as always, Mr. McSquirrel. You are the best McSquirrel of them all. And I'm glad that you don't keep yourself a secret and you share yourself with us. We are better for it. Simply Tanaka, whatever, Simply Tanika. Good morning. Love the morning voice. Good morning. CDs. Good morning, Mr. D's. Robert Glock, you look drunk still. Fun. Secret McSquirrel. Trish Norman. Naff. Narlf, good morning. Greetings from Germany. Good morning. Good morning from Germany. I don't know how similar the law in Germany is. Since it's not derivative of English law, I imagine there might be some significant differences. I wonder how different the law is in Germany. Good morning. Lady Sky, good morning. Man, that's good times. I am legal, Oklahoma City. Good morning, Uncivil. Good morning to you, sir. Or ma'am. Or other. Europe loves U.S. law. I bet they do. I bet they do. Thank you, Streamlabs, for telling us the rules. You know the rules, and so do I. Noosis, hello everyone, good morning. All right, let's do some bar exam now. We got some people rolling in. We're rolling in. Do some bar exam. Diamonds, and Hannah, good morning. You don't sleep either. Your lawyers are amazing like that. So, well, I have trouble sleeping. To be honest, to be fair, I was up at like 3 a.m. and then went back to bed. What subjects am I looking at today? I always look at all of them. I always look at all the subjects. Just my style. So yeah, we're doing all the MBE, all the things, all the subjects. Cheeky Monkey, Narlef, Amanda Sparkle, good morning. Miss Sparkle, thank you for bringing some sparkle to my life. I appreciate it. Do you already know when you take the exam, by the way? I do. Tuesday. Have I set the date for the exam? It's Tuesday. It's Tuesday and Wednesday. Yeah. Okay. Let's study. Melatonin to sleep? I do use melatonin to sleep. It does help quite a lot. Thank you. All right, let's see what we got. During a criminal investigation of possible securities frauds committed by senior management of a public corporation, The prosecutor has called a witness to testify before a grand jury. The witness will testify that he was an accountant for the corporation, that he dealt with senior management on a daily basis concerning the corporation's financial disclosures to the public, and in his opinion, all members of senior management knew disclosures were fraudulent. Can witness testimony be considered by the grand jury? Sure, why not? No, because the witness has not been qualified as an expert regarding financial fraud. That's not the standard, and even if it was, we're there. No, because the witness's opinion about senior management's knowledge is not rationally related based on his perception. Yes, it is. He was there. Yes, because the rules of evidence do not apply to grand jury proceedings. That's a little overbroad, but it's more true than not, to be honest. And yes, because the witness's opinion is rationally based on his perception, will be helpful to the grand jury. D sounds like the right answer. Yeah, it's a little bit overstating to say that rules of evidence don't apply. The rules of evidence are quite a bit different, though, at grand juries than regular juries. See? They don't apply at all. Oh, okay. There's different rules of evidence for grand jury. Okay, that's cool. Federal rules of evidence do not apply to grand jury proceedings. There are rules, just not the federal rules of evidence. Okay, cool. All right, fine. That works for me. You got this? Thank you. A plaintiff sued the insurer of her home after the insurer denied coverage for water damage to the home allegedly caused by a frozen plastic pipe that burst. At trial, the insurer called an expert witness as an engineer who testified the pipe had burst because of age rather than freezing. Fine. On cross-examination, the engineer admitted that 5 years earlier he had been convicted of tax fraud, even though he asserted it was his accountant's error. In response, the insurer calls a witness, who is well acquainted with the engineer and reputation, to testify that, in the witness's opinion, the engineer is a truthful person, and the engineer's neighbors all describe him as a truthful person. How much of any of this testimony is admissible? Well, you can't get the testimony from the neighbors because that's all hearsay. But as long as we're doing character evidence, then we can talk about things that are generally applicable. General things seems to be the standard rule. Okay, all the testimony is admissible to support credibility. Only the portion concerning engineer's reputation is admissible, because where both opinion and reputation evidence are admissible, only the latter is admissible under a rule of preference. Only the portion concerning the witness's opinion of engineer's character, because the witness is reporting the neighbors as hearsay. That sounds like the right one. None of the testimony is admissible because it's collateral, have no bearing on the qualifications as an expert. Well, it goes to his truthfulness, which apparently is already an issue. So his expertness is not the immediate problem. We're trying to rehabilitate him. So I think the answer is C. The comments from the neighbors are hearsay. A. Once a witness, okay, C. Under a witness's reputation is admissible form of character evidence is exception under hearsay rule. Right. Once a witness has been impeached based on character for untruthfulness, he may rehabilitate in form of extrinsic evidence, including another character witness testify regarding impeached truthfulness in the form of opinion and reputation. Okay. Under the federal rules of evidence, a witness's reputation among his or her associates or in the community concerning his witness character is an exception to the hearsay rule. Okay, great. Move on. Toxic materials being transported by truck from a manufacturer's plant to a warehouse leaked from the truck onto the street a few miles from the plant. A driver lost control of his car when he hit the puddle of the spilled toxic materials in the street and injured when his car hit the stop sign. Any action for damages by driver against manufacturer based on strict liability? No. Is the driver likely to prevail? No, because driver's loss is an intervening cause. No, because the driver's own injury did not result from the toxicity of materials. There you go. Yeah, that's not the problem. He wasn't injured by the materials exactly. So strict liability is the wrong thing. He was hurt by the fact that it was slippery, which is not a product liability issue. A plaintiff sued automobile manufacturing company for his wife's death, claiming that the defect steering mechanism on family car caused it to veer off the road and hit a tree while his wife was driving. The defendant claims the steering mechanism was damaged in the collision and offers testimony the deceased wife was intoxicated at the time of the accident. Okay. Testimonies concerning the wife's intoxication is what? Admissible will prove an alternative cause. Sounds plausible. Admissible is proper character evidence. No. Inadmissible because it's improper to prove character evidence by specific conduct. Inadmissible because it's substantially more prejudicial and probative. No, whether or not she's drunk at the time, and that was what caused her to hit the thing, is kind of relevant. So it's an alternative explanation for the accident's cause. Yeah. A buyer faxed the following signed message to his longtime widget supplier. Urgently need blue widget. Ship immediately 3 gross at your current list price of $600. Upon receipt of the fax, the supplier shipped 3 gross of red widgets, okay, to the buyer and faxed the buyer the following message. Temporarily out of blue. In case red will help, I'm shipping 3 gross at the same price. Hope you can use them. Okay, so he has a right to refuse them if they're not in conformity. He can accept them. He can do a lot of things. So what are we wanting to do? Upon buyer's timely receipt both of shipment and supplier's fax, which the following best describes his rights and duties? Well, he can accept them as non-conforming goods, and he can ship them back. And that's basically his options. Let's see what we got. The buyer may accept the shipment, in which case he must pay the supplier's list price, or he must reject the shipment and recover from them for total breach of contract. Possible. The buyer may accept the shipment, in which case he must pay the listed price, or he may reject the shipment, in which case he has no further rights against the supplier. Seems right, because he didn't have a contract. See, the thing is, they're not in breach of contract, because he basically he sent them an offer, kind of, or basically a request even. He's like, I'd like this, please. He sent his writing. It's like, well, we can't do that. So that's basically an inquiry at that point. His signed writing is kind of just an inquiry. So the offer technically is when the shipment occurs because it's non-conforming. So he can refuse, but there's no damages because there's no underlying contract. Because his writing is not enough to create the contract. So the shipment itself is proposal of the contract. So he can refuse, in which case there's no further rights because there's no breach of contract. Let's continue reading on. The buyer may accept shipment, in which case he must pay the supplier the list price, lest any damage is sustained because of non-conforming shipment, or he may reject this. He may reject the shipment. Well, this is horrifying. From True Crime Daily, courtesy of Stephanie. That's one way to sell teddy bears. Florida woman armed with pitchfork, whip, accused of trying to sell teddy bears behind Publix. I'm going to read this again. Florida woman armed with pitchfork, whip, accused of trying to sell teddy bears behind Publix. She, yeah. Well, where was I? I was trying to answer this question. Friends, if you're trying to sell teddy bears, maybe less with the whips. Just friendly legal advice. Carrying on. Or may reject the shipment and recover from supplier for total breach. There is no contract. The buyer may accept the shipment, in which case he must pay supplier the list price, less any damage is sustained because of non-conformant, or may reject the shipment provided he promptly covers by obtaining conforming monetages. B is the right answer. Yeah. His letter to the company is a solicitation. The offer was the shipment by the company. That was the offer. So there's nothing to breach. You either accept them or you don't. Moving on. A manufacturer of computers pays its salespeople a salary of $1,000 per month and commission of 5% on billings actually rendered for machines they sell. The manufacturer's salespeople are employed at will under written agreements which provide in order to receive the commission. The salesperson must be in the employment of the manufacturer when the bill is sent to the customer. This seems like a problem, but let's press on. In 2006, a salesperson for a manufacturer worked for 8 months to get an order from a large corporation for $750,000 of computers. He consulted extensively with the corporation's top executives and worked with its operating personnel to develop detailed specifications for the new equipment. He also promised the corporation, with manufacturer's knowledge and approval, to assist the corporation for 6 months after installation for making the equipment work. Okay. On January the 1st of 2007, the corporation signed an order, and on March 1st, the computers were installed. On March the 15th, the manufacturer filed the salespersons on the stated ground that he had failed to meet his 2005 and 2006 sales quota goals. This is apparently a harsh place. The salesperson thought the manufacturer was correct in this statement. So apparently his $750,000 of computer sales was not sufficient to meet his quotas. Okay, I mean, fine. A coworker was thereupon assigned to the corporation's account. On March the 31st, the manufacturer billed the corporation for the computers. Assume the manufacturer's termination of the salesperson was not wrongful. If the salesperson sues the manufacturer for reasonable value of his services, which of the following is the most likely result? The salesperson will win because the manufacturer benefited as a result of salesperson's services. The salesperson will win because the manufacturer made an implied in fact promise to pay a reasonable commission for services that results from sales. The salesperson will lose because there's an express contractual provision preempting subject of compensation for his services. The salesperson will lose because he cannot perform the agreement to assist the customer. Well, I'm going to go with implied in fact agreement. C. The express terms of the contract control the salesperson's right to recover and his reasonable expectations. Okay. An unmarried couple purchased a condominium as tenants in common and lived in the condominium for 3 years. Subsequently, they made a verbal agreement that on the death of either of them, no one cares because of the verbal agreement, the survivor would own the entire condominium. No. And as a result, they decided they did not need wills. No. 2 years later, the couple was involved in the same automobile accident. Oh my God. The woman was killed immediately. The man died 1 week later. Both died intestate. Okay, fun. The woman's sole heir is her brother. The man's sole heir is his mother. The brother claimed one half of the condominium, and the mother claimed all of it. The jurisdiction has no applicable statute except statute of frauds. It does not recognize common law marriages. Inappropriate action by the mother claiming entire ownership of the condominium, the court will find that. Okay. So a tenant in common, there's no right of survivorship. So once the person dies, the other person acquires what's left. So whoever dies first, their interest evaporates, and the other person has everything. So in this case, the woman was killed first, so her interest has disappeared. So the woman's sole heir is her brother, so not so much with the brother. The man's sole heir is his mother. The mother would be correct, since the woman died first. Yeah, okay. The mother owns the entire interest because the couple did not make wills in reliance upon their oral agreements and property, right? The mother owns the entire interest because she's entitled to reformation of the deed to reflect the verbal agreement. No. The brother and mother each own an undivided one-half interest because the couple each dies as a result of the same accident. That's not the law. The brother and mother each own an undivided one-half interest because the statute of frauds applies. No. The mother owns the entire thing because there's nothing to the contrary. No? Is the failure to put the agreement in writing, not the failure to make a will, that is a problem? I know that. The brother and mother each own an undivided one-half interest because the statute of frauds applies? Let me read the question again. An unmarried couple own tenants in common. Subsequently, they made a verbal agreement that on the death of either of them, the survivor would own the entire condominium. The oral agreement is no good. You need a writing for an interest in land. It's in the statute of frauds. Okay, so they have tenants in common. 2 years later, the couple was involved in the same automobile accident. The woman was killed immediately. Okay. Because it's tenants in common, her legal interest dies with her. No. I'm sorry, that's wrong. I'm wrong. I'm 100% wrong. That's my fault. That is completely my fault. No, I'm 100% wrong. Yeah. If it was joint tenancy, her interest would die with her and pass to the other person. Because they're tenants in common, their interests are each recognized separately. So yeah, that's the problem. So I just completely flipped the role in my mind. So they each own an undivided one-half interest because her interest does not die with her death. That's the nature of tenants in common. Her interest is inheritable. So yeah, I just completely flubbed that one. Well, that's okay. That's why we do these things. Since they're unmarried, why would they inherit anything? Well, because there's different kinds of property interests that exist, and you don't need to be married to have a joint tenancy. So there's 3 different kinds of property ownership when you have 2 different people involved. You have tenants in common, you have joint tenants, and you have tenancy in the entirety. Tenancy in the entirety is only for marriages, which this is not. So your only options left are tenants in common and a joint tenancy. You don't need to be married for a joint tenancy. So if they owned their property as a joint tenancy, the fact they're married is irrelevant. The nature of the joint tenancy is the thing that's driving it, right? Because they own it jointly, when one of them dies, they continue to own it jointly, but one of them is dead. So now the other person owns it completely because there's no one to join with, right? So that's why in a joint tenancy, that would be the rule. Here, this was set up as a tenant in common. So these are effectively strangers. And so they wouldn't, so that's the issue there. So hopefully that helps clarify that a little bit. An associate professor, in terms of who inherits without a will, yeah, it's your closest living relative. It's your spouse, and if not your spouse, then it's your parents, I believe, and then it's your children, or maybe it's the other way around. And then from there, we go to the table of consanguinity, where we determine how close everyone is in terms of being a blood relation to you. And that's where things get really fun. An associate professor in the pediatrics department of a local medical school was denied tenure. He asked the National Education Lobbying Organization to represent him in his efforts to have tenure decision reversed. In response to a letter from the organization on the professor's behalf, the dean of the medical school wrote the organization explaining truthfully the professor had been denied tenure because of reports that he had abused former patients. Well, that's a lot. Several months later, after a thorough investigation, the allegations were proven false, and the professor was granted tenure. Well, we're going to try defamation, but no. He had remained working at the medical school at full pay during the tenure decision review process and suffered no financial harm. In a suit for libel by the professor against the dean of the medical school, will the professor be likely to prevail? No, the thing here is I don't think we have communication with a third party, right? Because he asked the National Education Lobbying Organization to represent him. The letter from the dean is being sent to the organization in response to all this. So the thing that's failing here in defamation laws, I don't think we have communication to a third party, which you have to have. We're basically talking to the assistant professor, so you can't get to defamation. Let's read. No, because the professor invited the libel. Possible, that too. No, because the professor had suffered no pecuniary loss. This would be libel per se, because it goes to his job, so that's not the right answer. Yes, because the dean had a duty to investigate the rumor before repeating it. Yes, because it was the form of the writing. All right, so basically we're going to go with he invited the libel, I think, as the idea. Is that the right answer? It is the right answer. Although the professor could offer sufficient evidence for libel, the dean would be able to raise absolute privilege of consent, given the defamatory statement was a response to the initial letter from the organization acting on the professor's behalf, followed by authorized inquiry into the truth of the statement. There you go. So consent. He invited it. Or it's just him. Either way, take your pick. But yeah, that makes total logical sense. Pressing on. Which of the following items of evidence is least likely to be submitted without a supporting witness? Okay. In a libel action, copy of a newspaper purporting to be published by the defendant, newspaper publishing company. In a case involving contaminated food, a can label purporting to identify the canner as defendant company. In a defamation case, a document purporting to be a memorandum from the defendant company president to all personnel printed on defendant's letterhead. In a case involving injury to a pedestrian, a pamphlet on stopping distances issued by the State Highway Department. C is the problem, because anyone could get the letterhead. There's not sufficient. It's not sufficient. We have problems on the authentication. C is the issue. Is it? Yes, thank you. This item of evidence is least likely to be admitted without supporting witness because it's the only item that's not self-authenticating. Great. Moving on. A driver from State A brought negligence suit against a car manufacturer from State B in federal court in State A. The driver sought $100,000 as compensation for injuries suffered after the ignition of the driver's car allegedly malfunctioned. A jury found, pursuant to special verdict, that the car manufacturer was negligent. Okay. 3 months after final judgment was entered on the claim, the driver brought a products liability suit against them in federal court. Okay. Sounds like we're trying to recover twice, to be honest. It also sounds like it's part of a required joiner, so I'm thinking we're having some claim preclusion problems here, but let's read on. 3 months after the final judgment was entered on the claim, the driver brought products liability suit against the car manufacturer in federal court in State B. The driver sought injunctive relief to prohibit the car manufacturer from continuing to produce the type of injunction that malfunctioned the car. Oh, he's only seeking injunctive relief as opposed to monetary relief? Okay, we might be all right then. The car manufacturer filed a motion to dismiss, arguing claim preclude the second issue. Can we do this? Well, this is based in equity rather than in law because we're seeking an injunction. So let's read our options and see what we got. Okay, can we do this? Yes, because the driver's claim for injunctive relief is merged into the final judgment for the first suit. That sounds very plausible. Yes, because driver's claim for injunctive relief is barred by the judgment from the driver's first lawsuit. I'm not sure about that. No, because the driver's second suit seeks a different form of relief than was previously sought, so claim preclusion doesn't apply. That's not the right answer. No, because claim preclusion only applies when a party seeks to bring the same cause of action to the court where the first party of action is brought. That is definitely not true. So, is it barred from the judgment? No, I don't think it's barred. I think it's more likely that it's merged. So let's see if A is the right answer. It is the right answer. Yeah. It's merged. A student at a private university sued the university in federal court for negligence after he fell from scaffolding in a university-owned theater building. At trial, after briefing by both parties, the court permitted the jury to hear testimony that there had been several previous accidents in the same building. The jury found for the student, and the university appealed. One of the university's arguments on appeal is that testimony about previous accidents should have been excluded as too irrelevant and highly prejudicial. What standard of review applies? Abuse of discretion, clearly erroneous, de novo, or harmless error. Wow, let's try. This is going to be fun. All right, de novo is wrong because that deals with legal questions. This is not a legal question. This is a factual question. Okay, which standard is correct? Abuse of discretion. The issue is that it should have been excluded as prejudicial. It's not irrelevant, but it could be prejudicial, which seems like, so we're in section 403, but that's like a judgment call, which means that it's abuse of discretion. It is not. Clearly erroneous would be the correct standard if we were talking about a false finding of fact, right? This is not the correct fact. That's not what we're arguing. Clearly erroneous is wrong. Clearly erroneous is the legal standard you want if you want to say, hey, this fact the jury found, no, not so much. Or the judge found, right? That would be clearly erroneous. So that's not. Harmless error. Harmless error is the right standard if we made a mistake and we're trying to determine how much we care. But the immediate issue is abuse of discretion, I'm pretty sure. People are saying D instead of A. Let's find out. Determining relevance of evidence is within the trial court's discretion because it requires understanding of the entire case. Harmless error is incorrect because its conclusion an appellate court reaches after reviewing and determining the impact of the erroneous ruling, not the standard review the court applies in the first instance. Yeah. You don't get to harmless error analysis without first doing the abuse of discretion analysis. You do the abuse of discretion analysis, then you do harmless error. So your immediate problem is abuse of discretion. That was fun. A seller conveyed residential land to a buyer by warranty deed that contained no exceptions and recited the full consideration that had been paid. To finance the purchase, the borrower borrowed 80% of the necessary fund from the bank. The seller agreed to finance 50% of the purchase price, so the seller himself is acting as a lender on his own property. Okay. And the buyer agreed to provide cash for the remaining 5%. Okay, so we need to get money to buy the property. 80% of it we're getting from a bank, 15% of which we're getting from the seller of the property himself, and 5% of cash. Fine. At closing, the buyer signed a promissory note to seller for purchase price but did not execute a mortgage. That's a mistake. The bank knew of the loan made by seller and the promissory note executed by buyer to seller. The buyer also signed a note to the bank, secured by mortgage, for the 80% advance by the bank. The buyer is now defaulted on the loan. There are no applicable statutes. Who has priority? Well, without any sort of law to the contrary, the mortgage is going to win because the promissory note is now just personal debt. It's an unsecured debt. The mortgage would be a secured debt, so the secured debt wins. Which loan has priority? The bank's loan, because seller can finance a part of the purchase price only by use of an installment land contract. I doubt that's very much true. The bank's loan, because it was secured by a purchase money mortgage. There you go. The seller's loan, because a promissory note to a seller has priority over a bank loan for residential property. No, it doesn't. If you had recorded it, maybe, but you didn't, so no. The seller's loan, because the bank knew it an equitable vendor lien. No. The issue here is that the other guy simply has a promissory note. That is an unsecured loan. The bank has a secured loan. the bank is going to win. Of course. Next question. If he had recorded his promissory note, but he didn't, so yeah. A husband decided to kill his wife by poisoning her. Don't do that. Don't do the killing the wife with the poison. Or really with any method. That's not really cool. He asked his friend, a pharmacist, to obtain some whatever, a deadly poison, and to give it to him without recording the transaction. Pharmacists might be involved in potentially a conspiracy of some kind. Let's press on. Because pharmacists suspected the husband's motive, she supplied the husband with small quantities of something else, an antibiotic instead of the whatever thing we're trying to get. Okay. It's harmless if administered in small quantities, except for less than 1% of the population who's allergic. She's going to be allergic, and we're going to try to figure out who's guilty of murder. He is, by the way, because his malice is going to permeate. The pharmacist's liability, probably not, but he's guilty as hell. All right, so the husband injected his wife with the whatever while she slept. She was allergic to the drug, of course she is, and she dies from the injection. The pharmacist was distraught and confessed the entire affair to the police. Fun. Explained she had failed to report the husband's conduct to the authorities because she feared it would end their friendship if she did. In a common law jurisdiction, the husband is guilty of murder. Very much murder. Now, is he guilty of conspiracy? Is he guilty of conspiracy? Well, he entered into an agreement, and there is an agreement, and then one of the participants of the agreement, in common law, how deep are we doing the common law thing? Because strictly speaking, in common law, you only need the agreement. So we have the agreement. So I guess murder and conspiracy. No? Since the pharmacist did not have intent that a crime be committed, there was no agreement for commission of an offense. I suppose that's true. He didn't say, I'll do it, and then do it. He just did things. So there was no oral agreement. So we're looking for agreement by performance. And his performance was not in furtherance of it. And so he's not guilty of conspiracy because there's not two people involved in the conspiracy. Okay, fine. Representatives of states of individuals who died in an airplane crash in State A filed suit in federal court against foreign manufacturer of the aircraft that crashed. Foreign manufacturers may only be sued in federal court as a result of the Foreign Sovereigns Immunity Act, which grants federal jurisdiction over foreign instrumentalities when a foreign state engages in commercial activity. Prior to the law, the foreign instrumentalities were not suable at common law. The representative claim is based on wrongful death action and seeks monetary damages. The representative demands a jury trial. The foreign manufacturer moves to strike the representative jury demand. Are we likely to see it? So this is not a particular cause of action that was recognized in common law, but we're going to allow a jury because it's going to be similar to one that would have been allowed. So the fact that we've extended, yes, we can do this, I think. No, because the representative's claim is legal for the purposes of the right to jury trial under the 7th Amendment. No, because representative claim is equitable for the purposes of right to jury trial under the 7th Amendment. Yes, because a foreign manufacturer is not a proper defendant in a suit in common law in 1791. Yes, because providing the jury trial under the 7th Amendment would violate the FSIA. Does the FSIA prevent jury trials? Well, we're not going to have a case in state court A, but we're in federal court. Providing a jury trial would violate the FSIA. It doesn't say that, and I don't think that's true. A foreign manufacturer is not a proper defendant sued in common law. I don't think the analysis stops there. I think we reason by analogy, and so we basically ask, is this similar? I think. No, because the representative's claim is equitable. That's the wrong thing for a jury. No, because it's legal in its nature. Yeah, it's legal in its nature. So A. C. Okay. Has to be asserted against the type of defendant that was suitable at common law in 1791. Fine. Next question. How do you get the pharmacist to administer stuff without a prescription? The pharmacist has access to the drugs. He just gives them to you. It's not legal, but, he does it. The drugs are like right there, man. A car owner washed his car while it was parked on public street in violation of local ordinance that prohibits the washing of vehicles on public streets during specified hours. The ordinance was enacted only to expedite the flow of automobile traffic. Due to sun and unexpected cold weather, the car owner's wastewater formed a puddle that froze in a crosswalk. A pedestrian slipped on the frozen puddle and broke her leg. The pedestrian sued the car owner to recover for the injury. At trial, the only evidence the pedestrian offered as to negligence was car owner's admission that they violated the ordinance. Upon conclusion of the evidence, both parties moved for directed verdict. How should the trial judge proceed? Deny both motions and submit the case to the jury because of the facts. A jury may infer that the car owner was negligent. Deny both motions and submit the case to the jury because the jury may consider the ordinance violation as evidence of negligence. Grant the car owner's motions because pedestrians failed to offer adequate evidence the car owner was negligent. Grant pedestrians motions because car owners admitted violation. I would think there's enough here to go for A, but let's see what they want to say. Negligence creating a risk of icy service cannot be inferred from the mere fact the car owner allowed water to accumulate. The cold water was sudden and unexpected, but it was reality. Okay. The ordinance violation is irrelevant because the ordinance was not adopted to reduce the risk of ice accumulation. Okay. So we're trying to argue that the cold snap happened some period after, like, the car washer did his thing, and so he didn't see the cold snap coming. So basically what we're trying to go for here in this answer, we're trying to go for the idea that when the car owner was spraying the water around, it wasn't like incredibly cold weather, but somehow at some point after he did this car washing thing, it became sudden and unexpected cold weather at that point, and then it froze. So we're trying to detach. The thing we're trying to avoid, by the way, is his knowledge of the cold weather, because if it's freezing when he's going out and washing his car, then ice forming is kind of a natural thing. So we're trying to avoid that. So we're trying to argue the premise that when he went out, it was okay, but at some point after he did his thing, the water froze from the unexpected cold snap. And therefore, he didn't see that. It wasn't foreseeable, so there's no negligence. Okay. This is a strange factual picture to me, but okay, fine. A student broke into a professor's office in order to look at examination questions. The questions were locked in a drawer and the student could not find them. The student believed that looking at the examination questions was a crime, but this belief is mistaken. Charged with burglary, the defendant should be convicted of attempted burglary. Attempted burglary. Because he went in with the intent to commit a crime. Charged with burglary, he should be acquitted because he did not complete the crime and has not been charged with attempt. Acquitted because what he intended to do. Acquitted because what he intended to do when he broke in was not a crime. That's not the right answer. Convicted because he had the necessary mental state and committed an act of breaking and entering. That's not enough for burglary. You also have to have intent to commit a crime once you're there. Convicted because factual impossibility is not a defense. No, because he only wanted... No, factual impossibility is not the answer. Yeah, he's acquitted because he hasn't been charged with attempt. No? The requisite mental state for burglary is having intended to commit a felony or theft. Since merely looking at exam questions is not a crime and thus not a felony, they cannot be said to have intended to commit a crime. Bullshit. You have to have intent to commit a felony or theft. It is not, in fact, a felony. I know that. That's what makes it an attempt. A is incorrect. A burglary charge does not require actual commission of the felony. I know. Breaking and entering with intent to commit a felony would be sufficient. I know. Although the student did not actually find the questions, he could have been found guilty of burglary if he intended to commit a felony. I know. In this jurisdiction, looking at exam questions is not a felony, and therefore they did not have the requisite mental state. So he has to have intent to commit a felony or theft that is in fact a felony or theft. So it's not the fact that it's not burglary, or the fact that it's not illegal, but he has a guilty mind. I don't buy this at all. I don't buy this at all. I don't buy this answer. Moving on. A woman from State A sued a farmer in State B in state court in State B, alleging the farmer violated the workers' rights under Title VII of the Civil Rights of 1964. This is something we've been talking about recently on the channel, as some of you might be aware. The farmer filed notice of removal in federal court of State B. The worker then filed a motion for remand to state court. Should we grant the motion for remand? Yeah, it's a federal question, so sure. This isn't diversity, this is federal question, so the fact of the residencies is relevant, so sure. No, because the federal claim was mistakenly filed in state court. No, you can file federal claims in state court, that's cool. No, because the court had subject matter jurisdiction over federal question. They do, but that's not where it stops. Yes, because notice of removal should be filed with the state court. That doesn't even make sense. Yes, because the farmer is a citizen of State B, the state where the action was brought. I don't like any of these answers. Oh, to grant the motion to remand. Okay, let's try this. We're trying to remand back to state court. Okay, let's read the answers again. No, because the federal claim was mistakenly filed in state court. No. No, because the court has subject matter jurisdiction based on federal question. There you go. Yes, because notice of removal should be filed with state court. That doesn't make sense. Yes, because farmers is a citizen of State B. That would make sense if this was based on diversity, but it's not. It's based on federal question. So B. Yeah. It's B. D would be the correct answer if this was based on diversity, because you can't remove a case to federal court in diversity if it was filed in the state in which you are living. So if it's diversity and it's filed in state court, but you live there as the defendant, you can't remove that. But that's not true for federal question. So that's why it's B. Diversity versus federal question. That's it. That's exactly it. Yeah. Yeah. A police officer stopped the defendant for speeding late one night. Knowing the defendant was nervous, he ordered him from the car and placed him under arrest for speeding. By state law, the officer was empowered to arrest the defendant and take him to the nearest police station for booking. He searched the defendant's person and discovered a package of heroin in his jacket pocket. Okay. The defendant is charged with possession of heroin. At trial, defendant's motion to prevent introduction of heroin into evidence on the ground the search violated his federal constitutional rights will most likely be denied because the search was instant to a valid custodial arrest. Sounds very promising. Denied because the officer acted under reasonable suspicion and legitimate concern for his own personal safety. And there's no evidence of that, nor do we need it. Granted because there's no reason or proper basis on which to justify conducting the search. Lol. Granted because the officer was not in fear, had no suspicion to transport narcotics. No, search instant to a valid custodial arrest will be fine. Thank you. Moving on. I got pre-bar hairstyle. Don't I know it? Don't I know it? Yeah. A local telephone company negligently allowed one of its telephone poles located between a street and a sidewalk to become termite-ridden. A driver who was intoxicated and driving at an excessive rate of speed lost control of her car and weakened the telephone pole. 1 week later, the telephone pole fell and struck a pedestrian who's walking on the sidewalk. The pole fell because of the combination of the force of the car's impact and the pole's termite-ridden condition. If pedestrian asserts a claim against the telephone company and the driver, will pedestrian prevail? Yes, against the telephone company, but not the driver. Yes, against the driver, but not the telephone company. Yes, against them each for one half. Yes, against them each for the full amount of damages. Ooh, okay. So, okay. Can we get to... Now, the telephone company is totally fucked. Can we get to the driver? It's a week later. I'm having some causality issues here. I'm also having issues with foreseeability because that seems like a lot. I'm going to say the telephone company, but not the driver. I'm going to say that this is not a foreseeable consequence of the driver's negligence, among other issues. So the telephone company, but not the driver. Let's give it a try. No? Okay. The issue is an issue of a single indivisible injury. The separate and independent acts combined to cause the fall and cannot be apportioned. The facts do not indicate either action alone would have caused. A majority rule jurisdiction would hold the telephone company and driver jointly and severally liable. Okay. So we're ignoring all the foreseeability issues of the negligence, I guess. All right, pressing on. Yeah, we're apparently blowing past all those issues with the foreseeability issues. Okay. A trucker was making a delivery to a market that was located on the northeast corner of the intersection of Pine and Maple, both which are one-way streets. Traffic runs northbound on Maple and eastbound on Pine. Both streets have 2 stoplights each for oncoming traffic. At the time of delivery, there was insufficient space for the truck and its enclosed trailer in front of the market, so the trucker parked in such a way the trailer extended entirely across the crosswalk on the north side of the intersection, obstructing the northeastern traffic light that controlled oncoming eastbound traffic on the Pine. Unknown to trucker, the traffic light on the southeast corner of Pine had been knocked to the ground. A woman driving east towards the intersection could not see the red traffic light because the truck driver was blocking it. A man driving north entered the intersection without looking both ways and struck the woman's car. The man received personal injuries, and the woman's car was damaged severely as a result of the impact. State statute in place makes it a misdemeanor to park a motor vehicle so that any part of it projects into a crosswalk and to enter an intersection contrary to a traffic signal. If the man asserts a claim against the trucker and establishes the trucker was negligent, the likely result of the trucker's negligence is that it is a legal but not actual cause of the man's injury. It sounds promising. An actual but not legal cause of the man's injury is both a legal and actual cause, or neither. All right, so the man, who's the man? A man driving north struck the woman's car because presumably he couldn't see the lights. Or could he? Which lights are we talking about? It gets confusing. So the woman couldn't see lights, but he's driving differently. His view is not blocked. So the fact the trucker's doing whatever is not a legal or actual cause, if I'm understanding the call of the question correctly, which is assuming a lot. But I don't think if I'm understanding the way this is phrased correctly, it's not an actual nor legal cause. No? Okay, I misunderstood the question, I guess. Moving on. A state statute flatly bans the sale or distribution of contraceptive devices to minors. A national retailer of drugs and related items is charged with violating the statute. Which of the following is the strongest constitutional argument retailer could make in defending itself against prosecution for violation of the statute? For minors? The statute places an undue burden on interstate commerce. The statute denies minors one of their fundamental rights without due process. The statute denies a retailer the privileges or immunities of state citizenship. The statute violates the First Amendment right of freedom of religion because it regulates morals. What? D is wrong. Denies the retailer a privilege or immunity of state citizenship? Like what? Undue burden on interstate commerce? I suppose we're denying a minor a fundamental right without due process? Yes. Okay. It's just Eisenstadt versus Bard. Yeah, but did Eisenstadt deal with minors? That was where I was tripping up. Did Eisenstadt versus Bard deal with minors? That was where I was having like a moment of like confusion. And then I had to try to figure out whether or not it also applied to minors or not. So like the fundamental right to contraception, yeah, but for minors specifically, I was like, I don't know. I guess. All right, pressing on. A man's... Yeah, all right, well, yeah. A man suffered from the delusion that he was a special agent of God. He frequently expressed hallucinations in the form of hearing divine commands. The man believed God told him several times the local Roman Catholic bishop was corrupting the diocese into heresy, and the bishop should be done away with. The man, a devout Catholic, conceived of himself as a religious martyr. He knew that shooting bishops were hearsay against the criminal law, so he knows what he's doing is wrong. Promising. He nevertheless carefully planned how he might kill the bishop. One evening, the man shot the bishop, who was taken to a hospital where he died 2 weeks later. The man told the police he assumed the institutions of society would support the ecclesiastical hierarchy, and he expected to be persecuted for his God-inspired actions. A psychiatrist examined the man and found the man suffered from schizophrenic psychosis. In the absence of the psychosis, he would not have shot the bishop. And because of the psychosis, the man found it extremely difficult to determine whether he should obey the specific command that he do away with the bishop or general command, thou shalt not kill. Extremely difficult is not irresistible impulse, incidentally. So, no. If the man interposes an insanity defense, and the jurisdiction which he's tried has adopted only the McNaughton test of insanity, the strongest argument under the McNaughton test would be which of the following? The man did not know the nature of the act he was performing? Yes, he did. The man did not know the act he was doing was morally wrong? Possible. The man did not know the quality of the act he was performing? Yes, he did. The man's actions were the product of a mental disease. The man did not know his acts were morally wrong. Yes, he did. So let's go with D. Is it B? That's the Durham test or Prague test? Okay, well, fine. Pressing on. A man and his brother and cousins are charged in common law jurisdiction with conspiracy to commit larceny. The state introduced evidence that they agreed to go to a neighbor's house to take stock certificates from a safe in the neighbor's bedroom. They went into the house, and they were arrested as they entered the neighbor's bedroom. The man testified he thought the stock certificates belonged to the cousin. The neighbor was improperly keeping them from the cousin, and he went along to aid in the retrieving of the property. The brother testified he suspected the man and the cousin of being thieves, and joined up with them in order to catch them. He also testified he made an anonymous telephone call to police alerting them to the crime, and the call caused the police to be waiting for them when they walked into the neighbor's bedroom. The cousin does not testify. If the jury believes the man, they should find him what? Guilty because there was an agreement and the entry into the bedroom is sufficient for an overt act. Guilty because good motives are not defense to criminal liability. Not guilty because he did not have a corrupt motive. Not guilty because he did not intend to steal would be the correct answer. He thought the property was his. So there's no intent to steal. So there's no burglary. So it's fine. Moving on. A sailor filed suit in federal court against several boat manufacturers, all of which who used asbestos products on the ships they built. The sailor alleged that they had been exposed to asbestos while working in the naval shipyard. Discovery revealed that several ships containing asbestos had been at the naval yard where the sailor had worked at various times over the course of employment. Each of the named defendants manufactured ships. One of the named manufacturers moved for summary judgment, arguing the sailor had no evidence she had been exposed to asbestos products used by a particular boating manufacturer. In his motion for summary judgment, the manufacturer did not provide any evidence contradicting the presence in naval yard. It did not provide any support to negate the evidence put forth by sailor. Is the court likely to grant motion for summary judgment? There doesn't appear to be any dispute of facts. Okay. No, because the manufacturer failed to make the required affirmative evidentiary showing in support of its motion. No, because the manufacturer failed to make an affirmative evidentiary showing in support of its motion, or show absence of evidence in the record in the sailor's case. Yes, because it's clear there's no genuine dispute of material fact between manufacturer and seller. That seems right. Yes, because the sailor acted in bad faith when he filed suit without knowledge of which manufacturers were present. There doesn't appear to be any dispute of material facts, so motion for summary judgment would be great. Let's do that. No? The evidence of records does not itself establish sailors exposed to a boating manufacturer, only that they exposed to asbestos generally, in order that there be no issue as to material fact. The manufacturer would make a affirmative showing to undermine sailor's evidence in the record supports on motion. A defendant who moves for summary judgment may succeed either by demonstrating that no evidence in the record supports the plaintiff's case, or by showing of affirmative evidentiary support. In this case, while the evidence in the record does not alone establish Saylor's exposure to the particular manufacturer's asbestos, the evidence does support the Saylor's case generally. Therefore, in its motion for summary judgment, the boating manufacturer would have to either make an affirmative showing of evidence contradicting its presence in the naval yard or negating the evidence put forth by Saylor. Okay. You're mixed up too? Reread? It is early in the morning. Yeah. Pressing on. A drug company developed a new drug, ZB, for treatment of whatever. The company excessively tested the product for several years on animals and human volunteers and observed no undesirable side effects. The FDA approved the drug for sale. 5 other drug companies, each acting individually, developed drugs identical to ZB. Each of these drugs was also approved by the FDA for sale as a prescription drug. A wholesaler bought identically shaped pills. Okay. A wholesaler bought identically shaped pills from all 6 of the manufacturers and sold the pills to drugstores as whatever. Okay. The drug had a long-delayed side effect. Sons of male users of the drug are sterile. Holy shit. Okay. Well, all right. One such son brought an action against the drug company for damages. The drug company, through its wholesaler, supplied about 10% of the drug sold in the state where son lived. It is not possible to establish which of the 5 companies supplied the particular pills that son's father took. Okay. If the son asserts a claim against the drug company based on a strict liability and tort, which of the following will be a decisive question determining whether the son will prevail? Does res ipsa loquitur apply? Can liability be imposed on the drug company without proof the drug company knew the drug had undesirable side effects? Is the drug company relieved of liability by the FDA approval of the drug? Can liability be imposed on the drug company without showing that its pills were used? Yeah, that's going to be the biggest problem. That's going to be the biggest problem. Can we get to the drug company without showing that it was actually its pills that were used? That is going to be a problem. Thank God it's the right answer. That's a lot. All right. A plaintiff's estate sued a defendant, a store, claiming one defendant's security guards wrongfully shot and killed the plaintiff when plaintiff fled after being accused of shoplifting. The guard was convicted of manslaughter for killing the plaintiff. At his criminal trial, the guard, who was no longer working for the defendant, testified defendant's security director had instructed him to stop shoplifters at all costs. Because the guard's criminal conviction is on appeal, he refuses to testify at the civil trial. But he already testified at his criminal trial, so, okay, let's kind of read on. The plaintiff estates then offers an authenticated transcripts of the guard's criminal testimony concerning the instructions of the security director. Okay. The evidence is admissible as statement of an agent of a party opponent. Sounds promising. Admissible because instruction from the security director is not hearsay. Also promising. Admissible, although hearsay is former testimony. Inadmissible because not hearsay with any exception. What are we trying to get exactly? That the person said to stop him at all costs? As to that much, it's not hearsay, right? Because it's from the store. So the instruction from the security director is not hearsay. He's testifying to it, though. I'm going to say B. It's hearsay. C? You guys think C? You guys think C? Well, none of us were right. The guard's forward testimony is inadmissible hearsay because it doesn't qualify under an applicable exception. It is not an admission of a party opponent because the guard was no longer employed by the store when he made the statement, which means he was no longer an agent or employee. But what? The transcript is also not forward testimony because the defendant's store was not a party in the prior proceeding. The instruction is not hearsay. Why is B not right? There are two hearsay statements at issue. The statement made by the security guard to the security director, and testimony made by the guard to the prior trial. The security director's statement is included in the prior guard's testimony. For double hearsay to be admitted, both must be applicable. Although the director's statement may be admissible on its own, the guard's testimony does not meet the hearsay exception. All right, well, fine. Secret McSquirrel is leaving? No. Our life has diminished as a result. Our life has diminished as a result. Secret McSquirrel has left the chat. It is a sad day. Baby, come back. You're like a fool to me. Something can't get along without you. Baby, come back. Fool to see. Whatever. That's fine. We don't need him anyway. We don't need him. We'll press on. A woman entered into a contract with a painter by the terms of which the painter was to paint the woman's office for $1,000 and was required to do all the work over the following weekend so as to avoid disruption of the woman's business. Assume the following facts. If the painter had started to paint on the following Saturday morning, he could have finished before Sunday evening. However, he stayed home that Saturday morning to watch the final game of the World Series of TV and did not start to paint until, I was wrong, I just can't live without you, yeah. Baby, come back. You can blame it all on me. I was wrong. Just can't live without you. Thank you. Thank you for helping me with my lyrical endeavors on my quest to win America's Got Talent. Yeah. Okay, I'm skipping this question completely because I've distracted myself. I'm just passing this question. A plaintiff sued a defendant for damages arising out of an automobile collision. At trial, the plaintiff called an eyewitness to the collision. The plaintiff expected the eyewitness to testify she had observed the defendant's automobile for 5 seconds prior to collision and estimated the speed at time of collision to have been 50 miles per hour. Instead, the eyewitness testified she estimated the defendant's speed to be 25 miles an hour. Without finally excusing the eyewitness as a witness, the plaintiff then called a police officer to testify that eyewitness had told him during an investigation at an accident scene the defendant was doing at least 50. The police officer's testimony is... Okay, well... Is it admissible as a present sense impression? Is it admissible to impeach the eyewitness? Is it inadmissible because they may not impeach your own witness? Yes, you can. Inadmissible because hearsay, not with any exception. It's impeachment. B. Yeah. Next question. A bank teller was fired by the president of a bank. The teller wanted to take revenge against the president, but decided against attempting it personally because he knew the president was protected around the clock by bank security guards. The teller knew a man with a violent temper and who was very jealous. The teller falsely told the man's wife was having an affair with the bank president. Enraged, the man said, "What am I going to do?" The teller said, "If it were my wife, I'd just march into his office and blow his brains out." The man grabbed a revolver and rushed to the bank. He walked into the bank, carrying a gun in hand. One of the security guards, believing a holdup was about to occur, shot and killed the man. If he's charged with attempted murder of the bank president, the teller should be found very, very guilty. Very, very, very guilty. Guilty because he intended to kill the president and used the man to carry out his plan. Yeah. Guilty because he was extremely reckless as to the president. That too. Not guilty because the president was never in imminent danger. That's no. Not guilty because the man, if successful, would have been guilty of no more than manslaughter. I don't think so. All right. So is he guilty because he intended to kill the president and of the bank and used the man to carry out his plan, or not guilty because he was extremely reckless? Well, I'm gonna go with intent. Although reckless also seems like it works, but I'll go with A. Yeah. A charge of intent does require intent, that's true, as opposed to recklessness. Well, yeah, okay, never mind. Pressing on. After being fired, a woman sued her former employer in federal court, alleging the supervisor discriminated against her on the basis of sex. Well, contrary to rumors from some other people, I do actually understand the law when it comes to discrimination on the basis of sex under the federal labor law. I actually understand this stuff, so contrary to rumors, I know I understand these things. Let's see if I get the answer right. The woman's complaint included a lengthy description of what her supervisor had said and done over the years, quoting his telephone calls and emails to her, and her own emails to supervisor and manager asking for help. This sounds like a very promising complaint. The employer moved for summary judgment, alleging the woman was a pathological liar who had filed the action and included fictitious documents in revenge for having been fired. Because the woman's attorney was at a lengthy out-of-state trial when the summary judgment motion was filed, he failed to respond to it. The court therefore granted the motion in a one-line order and entered a final judgment. The woman has appealed. Okay. Is the appellate court likely to uphold the ruling? No, because the complaint allegations were detailed and specific. Yeah, I mean, summary judgment seems inappropriate because there does seem to be some pretty sharp disputes of fact here. No, because the employer moved for summary judgment on the basis the woman was not credible, creating a factual dispute. That's a reason not to grant summary judgment. Yes, because the woman's failure to respond to summary judgment motion means there was no sworn affidavit to support her allegations and supporting documents. Yes, because woman's failure to respond to summary judgment motion was a default, giving sufficient basis to grant the motion. I'm going to say A, that they're detailed and specific. Am I right? No. B, by challenging the woman's credibility in the motion, the employer disputed all the facts and evidence she laid out. Therefore, the motion did not meet the standard for judgment, and the trial court should be reversed. Well, yeah. The fact that the complaint's allegations were detailed and specific does not automatically prevent a court from giving summary judgment. Okay. Fine. Mark out one wrong. That's nice. A designer sued a fabric company in federal court for tortious interference with contracts. and advantageous business relationships. The designer claimed the fabric company orchestrated an internet smear campaign via anonymous postings disparaging the designer. As part of discovery, after weighing the value of anonymous speech against the need for relevant discovery, the district court ordered the fabric company to disclose the identity of persons directly responsible for anonymous postings. The fabric company petitioned for a writ of mandamus from the appropriate federal court of appeals directing vacatur of the disclosure. The fabric company maintained that requiring the exposure of anonymous non-party speakers would violate the First Amendment and would cause a substantial amount of harm. Is the Court of Appeals likely to grant the writ of mandamus? I would think not, no. Yes, if an appeal would be an insufficient remedy to correct the effects of the disclosure, and the district court's actions constitute a serious abuse of power in need of immediate reaction. Well, if you can get there, then okay. Yes, if it's likely that requiring exposures would cause harm. No, we're going to need a lot more than that. No, because the district court already ordered the disclosure and the fabric company has no means to rectify this action until a final adjudication. No, because writs of mandamus are not appropriate to reverse district court rulings. I mean, it requires a lot, but I think you're there if you can show all that. Yeah. Writs of mandamus in response to a trial judge action. I mean, okay. Why does the fabric company have identity of third parties? I don't know, but they do. Doesn't really matter. Was it on their blog? Maybe they have some information. I don't know. We're just going to assume they have it. It doesn't really matter why. The plaintiff took a diamond ring to a pawn shop and borrowed $20. It was agreed the loan was to be repaid within 60 days, and if not, the pawn shop owner, the defendant, could sell the ring. A week before the expiration of the 60 days, the defendant had an opportunity to sell the ring to a customer for $125. He did so thinking it was unlikely the plaintiff would repay the loan, and if he did, the defendant would be able to handle it somehow, even by paying him for the ring if necessary. 2 days later, the man came forward with the money to reclaim the ring. Defendant was told it had been stolen when his shop was burglarized one night, and therefore he was not responsible for the loss. That's just wrong on every possible level. Larceny, embezzlement, false pretenses, and robberies are separate crimes. Suppose that instead of denying liability, the defendant told plaintiff the truth. He had sold the ring because he thought plaintiff would not reclaim it, and offered to give the plaintiff $125. The plaintiff demanded the ring. The defendant said, "Look, buddy, this is what I got for it, and it's more than it's worth." The plaintiff reluctantly took the money. Which offense could the defendant most appropriately been found guilty of? Larceny. Well, he did convert property that was not his permanently, so larceny is promising. Embezzlement, that doesn't even begin to make sense. False pretenses. No, in this hypothetical as revised, there's no false pretenses. And robbery. No. Larceny you got, though. He converted someone's property with intent to permanently deprive. That is larceny. Embezzlement? Embezzlement is fraudulent conversion of another person's property by someone who's lawful possession. Oh, I guess you're right. I guess it is embezzlement. Wow. Yeah, I mean, that is embezzlement, now that you mention it. Yeah, that is embezzlement. You converted property that you had lawful possession of. It would be larceny if you took it away from him without consent. But you already had possession, so it's not larceny. I love it. I love it. This is a great question and a great answer. I love this so much. This is 100% correct. Right. Yeah. Larceny only works if I'm taking possession away improperly. But I'm not. I already have possession. So it's embezzlement. I love this answer very, very much. This is a great question. This is a great answer. This I love this very much. A computer company contracted in writing with a bank to sell and deliver to the bank a mainframe computer using a new type of magnetic memory, then under development, not perfected to the computer company at a price substantially lower than that of a similar computer using current technology. The contract's delivery term was FOB, the bank, on or before July 31st. FOB. I'm not sure what FOB stands for. I might have to fake my way into it. Assume the computing company tendered the computer to the bank on August the 15th, and the bank rejected it because of delay. If the computing company sues the bank for breach of contract, which of the following, if proved, will best support the recovery? The delay did not cause material harm. The computer company believed on assumption that the bank was getting a super deal. The computer company's delay in tender was caused by a trucker strike. A usage in relevant trade allows computer sellers a 30-day leeway and specified time of delivery, unless usage is negated. So that would help a lot if there is some sort of common understanding that pervades all the contract. Freight on board, I'm still no wiser as to what that means. But yeah, if it's common custom that 30 days is okay, then yeah, that would permeate the contract. A beverage company agreed with Fizzy Cola Company to serve for 3 years as distributor in 6 county areas for Fizzy Cola, which contains a small amount of caffeine. The distribution company promises in its contract to promote in good faith the sale of Fizzy Cola in that area, but the contract said nothing about restrictions on the products they could distribute. Okay. 6 months later, the business company agreed with the Cool Cola Company to distribute its caffeine-free cola beverages in the same area. If Fizzy Cola Company sues the distribution company for breach of distribution, which of the following would most help its case? Cool Cola's national advertising campaign disparages Fizzy Cola's products by saying, "You don't need the caffeine and neither does your cola." Since the distribution company began to distribute Cool Cola, the sale of Fizzy Cola has dropped 3%. Prior to signing the contract with Fizzy Cola, a representative of the distribution company said the deal would be exclusive. There we go. For many years in the soft drink industry, it has been uniform practices for distributors to handle only one brand of cola. Okay, so what is most helpful? An express representation would probably be most helpful. So I'm going to go with C. How long do I have before the test? It's on Tuesday. So 2 days. It's D. Okay, because Pro 11's rule? Okay, fine. Feeling a bit down today. I have a sneaking suspicion my passage on the bar exam is going to be very related to my mood that day. Or it could be. I need to do something that cheers me up. We're in Texas. I'm taking the bar in Austin. I'm taking it in Austin. How can we cheer you up? That's a good question. I appreciate that you're interested in cheering me up. I know what I can do that will help. I've got a Monster Energy in the fridge. So I'm going to get that and I'm going to drink it. I think that will help. Hold on. Damn it. talk amongst yourselves for a second. Alright, I'm going to put my clothes in the dryer as well while I'm up, so give me just one more second. Okay. Alright. Okay. Fuck. Alright. So, I didn't have any Monster Energy in the fridge. The container was empty. And I simply failed to... Yeah. Fresh air also helps. I can do that too. Also, I have the worst dryer ever. My apartment complex apparently picked the worst dryers ever, so I have to run the dryer for 3 different times because it sucks at drying. It fails in its one essential quest. Alright. Snort coffee powder. Yeah. Coffee is better than energy drink when it comes to your liver. Well, thanks, Mom. That's helpful. A senator makes a speech on the floor of the United States Senate in which they assert that William, a federal servant with minor responsibilities, was twice convicted of fraud by the courts of a particular state. Okay, we're making a speech on the floor of the United States Senate. We can basically stop the analysis automatically, but let's carry on anyway. In making the assertion, the state relied wholly on research done by the chief legislative assistant. In fact, it was a different man named William, and not William the civil servant who was convicted of these crimes in state court proceedings. The mistake was a result of carelessness on the legislative assistant's part. No legislation affecting the appointment or discipline of civil servants or the program of the federal agency for which the federal servant serves was under consideration at the time the senator made his speech on the floor of the Senate. The federal civil servant sues the senator and the legislative assistant for defamation. Both defendants moved to dismiss. As a matter of constitutional law, the court should hold which of the following. Grant as to the legislative assistant because he's protected by freedom of speech guarantee as against defamation against government officials based on mere carelessness, but denies the senator because as an officer of the United States, She's a constituent part of the government, therefore has no freedom of speech rights in this capacity. Fuck you. Grant as to both defendants, because the senator is immune from any speech they make in the Senate. There you go. Under the speech and debate clause of Article 1, Section 6, and the legislative assistant may assert the senator's immunity for assistance in preparing speech. That sounds very, very promising. Denied as to both defendants, because any immunity of the senator under the speech or debate clause does not attach to a speech that's not germane to pending legislative business. And the legislative assistant is entitled to no greater immunity than the senator. Who's coming up with these questions? No, that's okay. D, denied as to the legislative assistant because he's not a legislator protected by speech or debate, but Grant is the senator because they're immune. All right, so the question is, can we get to the legislative assistant? And I'm going to say it's too wrapped up in the speech and debate clause to work. So, yeah. Because defamation doesn't really work here. So I'm going to say B. Thanks. Also, incidentally, because I now am self-employed, I now also have to buy healthcare for myself on the exchanges, which I've yet to do. And I have to do that pretty soon because my healthcare is running out. I got 30 days for free, and yeah, so I got to buy healthcare. A cyclist from State A filed a negligence action in federal court in State A against a driver from State B following an accident. A jury of 12 people returned a verdict for the cyclist and found the cyclist was not contributory negligent. After receiving the verdict, the presiding judge, on her own motion, polled the jurors individually. The judge polling revealed the jury's verdict was not unanimous in deciding the cyclist had been exercising due care and was not liable under contributory negligence. As a result, the judge ordered a new trial. The cyclist finally filed a notice of appeal. Are they likely to get it? Not really. Yes, because the court should have directed the jury to deliberate further when polling showed it was not unanimous. That is a thing they could have done, but yes, because contributory negligence is not a defense to negligence in federal court. What? No, because the federal court has no authority to poll the jury on its own motion. Bullshit. No, because the Court of Appeals should dismiss the appeal for lack of jurisdiction. Yeah, it's not final, so there's no jurisdiction. Yeah, D. Next. I vote we get Kurt an assistant for Christmas. Yeah, Kendra, I've been looking into this a little bit. In terms of trying to find professional help that might be able to assist the channel. Like trying to find someone who would be a YouTube channel manager in a full-time capacity, or at least in a professional capacity. This, of course, to help with things the channel needs. I don't 100% know exactly what it is I'm looking for. And the companies I've inquired with, I'm not 100% confident in. So things are going a little bit rough. So, yeah. But we could use some kind of assistant. We could use some kind of social media manager. I would imagine that this person's role would be such things as helping with title selection, helping with writing descriptions of videos, helping with finding the appropriate tags for the search engine optimization, helping with discovery of stories, helping with promotion of the channel using backlinks, for example, and so forth and so on. So yeah, I'm looking into it. Yeah. A state generally provides funding for the medical care of its residents who cannot afford such care. State law, however, prohibits the use of state funding for surgery to any person who has resided in the state for less than 1 year, except emergency situations. Yeah. Well, yeah. A woman moved to the state 2 months ago seeking permanent employment. Her physician recommends non-emergency surgery to treat a medical condition. The surgery would qualify for state funding if the woman had resided in the state for a year. The woman has sued to invalidate the state law that prohibits the state funding of her surgery. Should the woman prevail? No, because the law reasonably conserves the state's limited resources. No, because the law reasonably prevents the expenditure of state funds on transient non-residents. Yes, because the law burns the woman's fundamental right to health care. Yes, because the law burns the woman's fundamental right to travel. All these options suck. Privileges and immunities is much better. I guess B. I don't like any of these answers. The woman's fundamental right to travel interstate includes the right to be treated equally with other residents of the state in which she lives, even if she's a new resident. I wouldn't say the right to travel does that. I would say that it is the privileges and immunities. You have coffee ice cream? That's pretty awesome. A landowner owns and operates a 12-story apartment building consisting of 72 apartments, 70 of which are rented. A pedestrian has brought an action against the landlord, alleging that while they were walking along the public sidewalk adjacent to the landlord's apartment building, a flower pot fell from above and struck him on the shoulder, causing injury. The action was to recover for the injury. If the pedestrian proves the following facts and no other evidence is offered, will he survive a motion for a directed verdict? Yes, because the pedestrian was injured by artificial condition of the premises while in an adjacent public way. Yes, because such an accident does not normally happen absent negligence. No, because the landlord is in no better position than the pedestrian to explain the accident. No, because there's no reasonable basis to assume the landlord is negligent. That would be the right one. All right, kids, it's time for me to retrieve my coffee from the coffee machine that has been made. Hold on. Making coffee with Uncivil Law. It's how we get started in the morning with Uncivil Law. Making coffee in the morning with Uncivil Law. Do we like coffee in the morning with Uncivil Law? Yes, we like coffee in the morning with Uncivil Law. Let me try this and see if this works out at all. Doing experiments with my coffee with Uncivil Law. Trying a completely new thing, seeing if it works with Uncivil Law. How y'all doing? Mask up when I go. Maybe. We'll see. Sent me a Discord message. Let's take a look. Coffee. Under the terms of his duly probated will, a testator devised his house to his grandchildren in fee simple, and the residual of his estate to his brother. The testator had 2 children, a son and daughter, but only the daughter survived the testator. At the time of the testator's death, the daughter was 30 years old, and had 2 minor grandchildren, who also survived the testator. A third grandchildren of the testator, who was the child of the testator's predeceased son, had been alive when the testator executed the will, but had predeceased the testator. Under applicable interstate succession law, the deceased grandchild's sole heir was his mother. The statute of the jurisdiction provides as follows. If a devisee, including devisee of a class gift, who is a grandparent or lineal descendant of a grandparent of the testator, is dead at the time of execution of will or fails to supervise the testator, the issue of such deceased devise shall take deceased share under the will, unless the will expressly provides the statute shall not apply. For these words of survivorship, if he survives me, are sufficient, the statute shall not be survived. Who now owns the house? This is some very unbelievable bullshit. I'm going to say C. The surviving children and any other grandchildren born. No. I'll give up. Chat must be on topic. What the ... Yeah, what a strange idea that chat in a chat room should be on topic for the chat. Wow, that's really a burden. In a civil suit by a plaintiff against the defendant, the defendant was called a chemist as an expert witness and asked him a number of questions about his education experience in chemistry. Over plaintiff's objection, the witness was not shown to be qualified in chemistry. The trial court permitted the witness to testify as his opinion in response to a hypothetical. On cross-examination, what? On cross-examination, plaintiff asked the witness if he had failed 2 chemistry courses while doing graduate work. The answer should be admitted because it's relevant to weight. Admitted because specific acts bearing on truthfulness may be inquired about on cross-examination. Excluded because the court has determined that witness is qualified to testify. Excluded because witness character has not been useful. I say it's relevant as to weights, to be honest. I mean, you're too literal in your answers. You need to chill. Well, do you have a video that explains what you're looking for? Not really, no. In terms of the channel, no, not really. I don't really 100% know what I'm looking for. Tanya says drama is never good. I tend to agree. We're here for Captain Kurt, yeah. Maybe I'm wrong about such things, but, you know, like, if I have a rule that says, like, for example, be on topic, which seems like a pretty reasonable rule. It's like we want the chat to be on topic. And then someone comes in, like, be on topic. What kind of rule is that? It's like, well, you know, yeah, I'm going to mock that because it's like, it's what kind of comment is this? Maybe I'm wrong for doing that. I don't know. Maybe I'm wrong for that. But it's like, you know, someone's giving me crap, so I give them crap back. And like, they're giving, what kind of rule is this? They're giving me crap, so I'll give you back crap back. It's like, oh, you're so mean to your people. Excuse me 1 second, there's a bug. No, Captain Kurt is fine. That's fine. We're not talking about you. You're fine. You're good. Did I get my YouTube play button? Yes. Yep. It's right there in the background. It's right there. You can discuss coffee when I'm making coffee. I mean, it's kind of on topic at that moment, isn't it? I mean, that's fine. On March the 31st, a seller and a buyer entered into a written agreement which the seller agreed to fabricate and sell to a buyer 10,000 specially designed brake linings for a new type of power brake manufactured by the buyer. The contract provided that the buyer would pay half the purchase price on May 15th in order to give the seller funds to tool up the work, that the seller would deliver 5,000 brake linings on May the 31st, that the buyer would pay the remaining balance on the purchase price on June 15th, and the seller would deliver the rest of the brake linings on June 30th. It is one sexy button. Let us show off the button again because it makes me happy in my day. Let us show everyone the button. Very exciting. Let's have time with the button. Let's have time with the button. Button time. Button time. To Uncivil Law for passing 100,000 subscribers. Button time. Button time. Button. Button. I love you, bud. I love you too, Uncivil. What do you think, Uncivil? Well, I think you're doing great. Thanks. Mirror, mirror of the button, who is the greatest of them all? You are, Kurt. You're the greatest of them all. Aww, the button loves me. Thus, that concludes button time. Thank you. Yeah, so what are we looking for in terms of a social media manager? I suppose the easiest answer to that question is someone who can help this channel become 1 million subscribers strong. Right? What can we do? I want to be the creative. I'm the creative. I'm the content maker. So we need, basically, for lack of a better description, a producer. And someone who will help in all the sort of stuff to make the channel do as well as it can. So that kind of stuff. You need that in a clip? No clips for you. Okay. Let's skip this question. In fact, I think I'm going to just skip the bar exam completely for the moment. Maybe we'll just play some games or something. How am I doing so far? Probably not that great. 39 questions this log on. Let's see if let's do 50. Let's go to 50 questions. Let's do 11 more. I can do 11 more. I'm going to pass this question, but we'll do 11 more. A buyer purchased 100 bolts of standard blue #1 quality from the seller. The sales contract provided the buyer would make payment prior to inspection. The 100 bolts were shipped and the buyer paid the seller. Upon inspection, however, they discovered they're #2 quality. #2 is just not #1. The buyer then tendered back the wool to the seller and demanded a return. No problem, that's great. The seller refused on the ground there's no difference between #1 and #2. There must be, because you gave him two different numbers. Which is the buyer's remedy? What is the buyer's remedy because the wool was non-conforming? Specific performance, good luck. Damages measured by the difference of the value of goods delivered and the value of conforming goods. Damages measured by the price paid plus difference between the contract price and cost of buying substitute goods. Non-since he waived his remedies to agree to pay before inspection. That's bullshit. So damages measured by price paid plus differences between the contract price and cost of buying substitute goods. That sounds a lot like the right answer to me. There you go. What did I do before YouTube? I don't really talk about my day job, and I'm not going to change that rule. What I tell people is that I was I was involved in transactional on patent prosecution. I helped patents become things. So that's what I did. I was in the transactional side of patent prosecutions, helping patents become patents, helping them become into patents. That's what I did. Non-litigation, if that's your question, by the way. Yeah. On June the 1st, a seller and buyer contracted in writing for sale and purchase of a seller's cattle ranch, a large single tract and closed transaction on December the 1st. The buyer unequivocally repudiated the contract on August 1st. On August 15th, the seller urged the buyer to change her mind and proceed with scheduled closing on December 1st. On October 1st, having heard nothing further from the buyer, the seller sold and conveyed his ranch to rancher without notice to buyer. On December 1st, the buyer attempted to close on the June 1st contract by tendering full purchase price. The seller rejected. If the buyer sues for breach of contract, the buyer will probably win because the seller failed to seasonally notify the buyer of any pending sale. Win because the seller waived the buyer's first repudiation by urging her to retract. No. Lose because the buyer did not retract the repudiation before seller materially changed the position or reliance thereof. That sounds real promising. Lose because acceptance of the purchase price by seller was a concurrent condition to convey. No. Material reliance sounds like the right answer to me. Yay. Okay. A developer obtained a bid of $10,000 to tear down her old building and another bid of $90,000 to replace it with a new structure in which she planned to operate a sporting goods store. Having only limited cash available, the developer asked the lender for a $100,000 loan. After reviewing plans for the project, the lender signed in a writing promise to lend the developer $100,000 secured by a mortgage on the property and repayable over 10 years in equal monthly installments at 10% interest. The developer promptly accepted the bid and the old building was removed, but the lender thereon refused to make the loan. Despite diligent efforts, the developer was unable to obtain a loan from any other source. Assumed developer has a cause of action against the lender. If we sue him for monetary relief, what's the most probable measure of recovery? It's going to be basically your reliance damages is the most likely. Expectation damages measured by the difference between the value of the new building and the old building, less the amount of the proposed loan. Expectation damages measured by the estimated profits from the operating of the proposed store. Reliance damages measured by the $10,000 expense of removing the old building, adjusted by the decrease or increase of the market value of developer's land immediately thereafter. That sounds really promising. And nominal damages only, because both expectation and reliance damages are speculative, and there's no legal or equitable basis. That's bullshit. So I think we're going to talk about reliance damages, probably. Yeah. A state law provides for an award of damages against anyone who publishes the name of a sexual assault victim. Pursuant to law, a woman sued a local newspaper in state court after the newspaper identified her as such a victim. The state trial and appellate courts rejected the claim, holding state law was invalid under both the state constitution and the First Amendment to the Constitution. The state Supreme Court affirmed, holding specifically, "We think that this very well-intentioned law very likely violates the First Amendment of the federal Constitution. We need not, however, decide that issue, because the law assuredly violates our state constitution, which provides even greater protection to the right of press to report the news." The women petitioned for review of the Supreme Court. Is the Supreme Court going to grant the review? Absolutely not, my friend. An independent and sufficient basis under state law to decide the issue, the Supreme Court does not have jurisdiction. Is the Supreme Court going to review? No, because the First Amendment prohibits the imposition of liability for publication of truthful information. No, because judgment of the Supreme Court rests upon an adequate and independent state ground. Those are the magic words. Yes, because the Supremacy Clause does not permit a state to grant rights greater than those conferred. Of course it does. Yes, because the Supreme Court appellate jurisdiction extends to cases arising under federal law. But there isn't federal law in play. It's only state law in play. So the answer is B. B is your answer. Adequate and independent were your magic words for the day. State authorities received information that a man had been making threats against his ex-wife. To determine whether the man was serious, an undercover officer introduced himself to the man at a bar. The officer said that he had previously taken care of problems for angry spouses. After some discussion in which the man expressed his extreme anger at his ex-wife, the man offered the officer $5,000 to kill her. The officer agreed and made arrangements to meet the man the next day to collect the $5,000. When the man showed up, they arrested him. The jurisdiction defines attempt, solicitation, and misprision of a felony at common law, and also punishes bilateral conspiracies. The crimes are listed in descending order of seriousness. Which is the most serious crime of which the man can be convicted? Can we convict him of attempted murder? Well, we do intend to murder, and we've taken a substantial step there too. So I think attempted murder is looking pretty promising. Can we do conspiracy? No, we can't, because we only do bilateral conspiracies, and the way this is phrased, it is not a bilateral conspiracy. Solicitation, we definitely got that. And misprision of a felony, I'm not quite sure how that applies, to be quite honest. So I think attempted murder, because we have intent to commit murder, and we're committing a substantial step in furtherance thereof for the attempt. So I think A. No. The facts show the man did not take sufficient steps. The man did nothing but offer to pay, and the conduct is not dangerously proximate to the commission. Okay. Yeah, and then it notes here that misprision is not applicable, because misprision is when a person knows about a felony but fails to inform authorities, which isn't really an offense anywhere anymore. And under the federal law, you still have to show, like, what is it? You have to show basically some obstruction on top, because misprision of a felony is listed as a federal crime, but it requires additional element that's not actually there as a matter of law. So yeah, misprision of a felony. Yeah, misprision of a felony is not really a thing that exists. It's not surprising that you haven't heard of it. Misprision of a felony is where you know about a crime and you fail to report it. That's misprision, and it's really not a thing. There is a federal law that states misprision of a felony, but in order to do that, according to the Supreme Court, you have to like be involved in the crime or some way or something. Like, it's not enough to merely know. So I don't know that, strictly speaking, misprision, mere knowledge of a crime is not enough to gain liability. But yeah, it used to be, and it's not now. Entrapment? Not a chance on entrapment. Not a chance on entrapment. The plaintiff sues the bar for injuries suffered in an automobile accident caused by a patron of the bar. The plaintiff claims the patron was permitted to drink too much liquor at the bar before the accident. A witness who was present at the bar on the night of the incident testifies on the night of the incident at the accident the patron was drunk. The witness then proposed to testify. He remarked to his companion, "That patron is so drunk he can't even stand up." The witness's remark to the companion sounds a lot like hearsay to me. Admissible as an excited utterance? No. Admissible as a prior consistent statement? No. Admissible as a statement by a witness regarding a condition he observed made while observing it? Possible. Inadmissible if there is no evidence the witness had expertise in determining intoxication. No, it's something a normal person could observe, so the answer C is the best answer. And it is the best answer. How are we doing? $45 questions down. Let's do 5 more. Why not a chance of entrapment? There's no chance of entrapment because he wanted to commit the murder before the police ever did anything. Right? Entrapment only occurs when, essentially, for lack of a better description, the police overcome your will. So it is when entrapment is basically when the police coerce you, or they duress you, or they do other things that overcome your ability to make a free choice yourself. This guy wanted to kill his wife before he ever walked into that bar. The officer saying, "Hey, you want to kill your wife?" No, it's not entrapment because he isn't being coerced. He's not being duressed. He's not being forced into it in any way. He's making a free choice in furtherance of his underlying intent. So, entrapment is a total non-starter. The police can lie to you. So, yeah. A state statute requires that all buses which operate as common carriers on the highway of the state shall be equipped with seatbelts. An interstate carrier challenges the validity of the statute of the right to make the requirement. What's the best argument? I'm going to know this without reading it. Dormant Commerce Clause. Violation of due process, violation of equal protection, unreasonable burden on interstate commerce, difficulty of enforcement. Unreasonable burden. Dormant Commerce Clause. A dry goods retailer telephoned a towel manufacturer and offered to buy for $5 each a minimum $500 and a maximum $1,000 large bath towels to be delivered in 30 days. The manufacturer orally accepted this offer and promptly sent the following letter to the retailer, which retailer received 2 days later. This confirms our agreement today to sell you 500 bath towels for 30 days delivery. 28 days later, the manufacturer tendered the retailer 1,000, not 500. Conforming bath towels, all of which the retailer rejected because he found a better price. No. Because of a glut in this towel market, the manufacturer cannot resell the towels except at a loss. In a suit by manufacturer against retailer, which of the following is most probable? The manufacturer can enforce a contract for 1,000 towels because the retailer ordered and the manufacturer tendered. The manufacturer can enforce a contract for 500 because the manufacturer's letter of confirmation stated the quantity term. Sounds promising. There's no enforceable agreement because the retailer never signed a writing. There is no enforceable agreement because the manufacturer's letter of confirmation did not state a price term. It doesn't need to. So the question they're trying to ask me is this note that's not signed sufficient for the statute of frauds? Is a writing 500 towels. I'm going to say the manufacturer's letter of confirmation stated the quantity term. Yeah, that sounds right. I'm going to say B. Yeah. Under the Uniform Commercial Code statute of frauds, a contract for the sale of goods of $500 more is not enforceable unless there's a writing sufficient to indicate a contract has been made, which is signed against the party of whom enforcement is sought. The writing need not contain all the terms of the contract, but it's enforceable only to the extent the quantity terms stated in the writing. The contract between manufacturer and retailer for 500 towels falls within the statute of frauds because it's over $500. However, when dealing with two merchants, there's something called the confirmatory memo rule. In contracts between merchants, if one party, within a reasonable time after an oral understanding has been reached, sends written confirmation to the other party, it will satisfy the statute of frauds against that other party as well if the recipient knew the contents and failed to object, blah, 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 some UCC stuff. So, yeah. A landowner owned in fee simple lots 1 and 2 in an urban subdivision. The lots were vacant and unproductive. They were held as speculation their value would increase. The landowner died and, by his duly probated will, devised the residue of his estate, of which lots 1 and 2 were part, to his sister for life, with remainder in fee simple to niece. Cool. The landowner's executor distributed the land estate under the appropriate court order and notified sister that future real estate taxes in lot 1 and 2 were her responsibility to pay. Yep. Except for the statutes relating to probate and those relating to real estate taxes, there's no applicable statute. The sister failed to pay real estate taxes due for lot 1s and 2. To prevent a tax sale of the fee simple, the niece paid the taxes and demanded reimbursement. Yeah. When sister refused, the niece brought appropriate action. Niece will recover when she's out. The amount paid because the life tenant has a duty to pay current charges. Sounds right. The present value of the interest of the amount paid that they would earn. No. Nothing because the sister's sole possession gave the right to decide whether or not to pay taxes. No. Nothing because they never received any income. No. Yeah, the amount paid because the current owner has the duty to pay the current charges. Okay. The general rule is the life tenant is responsible for real estate taxes on property and interest on principal to the extent of income of the property. However, a life tenant is liable to holder of a future interest for property taxes only to the extent rents received or fair market value of the property if the life tenant is occupying the property. In other words, if the life tenant is not occupying the property and not renting the property, then the future interest holder, upon coming into present possession of the property, will be unable to sue for unpaid taxes. Okay. Noted. Two more. In the course of a bank holdup, a robber fired a gun at a guard. The guard drew his revolver and returned fire. One of the bullets fired by the guard ricocheted, striking Plaintiff, who was simply a customer at the bank. If the plaintiff asserts a claim against the guard upon his battery, will they prevail? No intent. Also, to the extent there is intent, intent follows the bullet. He was privileged in his use, and so no battery. All right. Yes, because the plaintiff was not robber's accomplice. Yes, under the doctrine of transfer intent. No, because the guard filed reasonably in his own defense. No, because guard did not intend to shoot plaintiff. Reasonable in his own defense is what we're trying to do here. One more. Redirection of examination of a witness must be permitted in which of the following circumstances? Must be permitted? To reply to any matter raised in cross-examination, only to reply to significantly new matters raised in cross-examination, only to reiterate essential elements of the case, only to supply significant information inadvertently omitted on direct. B. I mean, you can kind of get your way through that one. All right, so how did we do today on the 50 questions we answered? Let's see. We got 60%, which is not stellar, to be honest. Of 50 questions, that is like some bare minimum threshold for passing bullshit right there. So if we score 60%, we're likely to not pass the bar exam, then that sucks. Our overall rate is sitting at 63.7% with 973 questions answered. So, yeah. %60 is probably good enough. What's Taxes' pass rate? I'd have to double check. I think it's either like 66 or 70%, something like that. So it's either 2/3 or 70%. Yeah, 60% is not that great. No, it's not. 60% is like bare minimum. It is not great. If we're getting 60%, we're failing. So neatly 70 or 80. I forget overall what you need. But yeah, we need to like pick up on that some more. I'm trying to decide if I have the will right now to do any more questions right now. And if doing any more questions right now would be productive. The exam is 3 parts. It's multiple choice, it's essay, and it's something called the MPT, where they give you a closed problem. So they give you all the information that they need, and then they ask you to write something relating to the problem. The thing they ask you to produce could be, for example, a letter to a client. It could be a motion to a court. It could be, a lot of different things. You won't have distractions during the exam, yeah. I say what lifts your mood. You guys want to play some Fall Guys? I'm not even sure that would help improve my mood, to be honest. It takes us to 270 out of 400. So that's about 68%. Long time since I took the LSAT. I don't really have any advice on the LSAT. Are the 3 parts equally scored? I honestly don't know how the scoring is broken up between the 3 parts. I'm going to try to do some more questions, I think. $100 questions. I can't do 100 questions right now. 60% isn't too bad. It's like about average. It could be better. Yeah, 70% is a good goal. We'll try to do a few more. On June the 1st, a seller and buyer contracted in writing for sale and purchase of Sailor's Cattle Ranch, a large single tract, and to close on December the 1st. On October the 1st, the buyer told the seller, "I'm increasingly unhappy about our June 1st contract because of the current cattle market and do not intend to buy your ranch unless I'm legally obligated to do so." If seller sues the buyer on October the 15th for breach, the seller will probably win because the buyer committed total breach of anticipatory repudiation, win because the buyer's October 1st statement contained reasonable grounds for seller's insecurity with respect to performance, lose because the parties contracted for sale and conveyance of a single tract and seller cannot bring suit for breach of such a contract prior to the close date, lose because the buyer's October 1st statement was neither repudiation nor present breach. I'm going to say D. It's not specific enough for repudiation. It has to be unambiguous. Try to keep your chin up. Thank you. I will try. Two salesmen who lived in different suburbs 20 miles apart were golfing acquaintances at an inner urban country club. Both were traveling salesmen, one for pharmaceuticals and the other for widgets. The pharmaceutical salesman wrote the widget salesman by United States mail on October the 8th. I need a motorcycle for transportation to the country club and like to buy your bike for $1,200 upon your bringing it to my home address. On or before noon, November 12th next. This offer is not subject to countermand. The widget salesman responded by mail the following day. I accept your offer and promise to deliver the bike as you specified. This letter, although properly addressed, was misdirected by the postal service and was not received by the salesman until November the 10th. The pharmaceutical salesman had brought another bike from a different friend for $1,000 a few hours before. The friend saw a widget salesman at the inner urban county comes on the 11th said, I sold my bike to the salesman yesterday for $1,000. Would you consider selling me yours for $950? The widget salesman said, I'll let you know in a few days. Oh my God. On November 12th, the widget salesman took the bike to the pharmaceutical sales residence. He arrived at 11:15. The pharmaceutical salesman was asleep and did not answer the ringing doorbell until 12:15. The pharmaceutical salesman then rejected the widget salesman's bike on the ground that already bought someone else's bike. In the pharmaceutical salesman letter of October 8th, what was the legal effect of saying this offer is not subject to countermand? Under the Uniform Commercial Code, the offer is not revocable until noon, November 12th. Such language prevented effective acceptance by the widget salesman prior to noon, November 12th. At common law, such language created a binding option in the widget salesman's favor. Such language did not affect the power of revocation. I'm going to say A. No? The firm offer rule is limited to merchants. Okay. Okay. Yeah. There are a lot of questions that use the same fact pattern and then ask you different questions on it. So yeah, we've seen that question a couple different times with a couple different questions based on it. We've definitely seen it before. A plaintiff domiciled in State A brought a federal diversity negligence action in State A against a defendant domiciled in State B. The action was based on an accident that occurred in State B, State C. Defendant was personally served with process at the office at State B, which is located 500 miles from State A federal courthouse. The defendant travels to State A once per year for a weekend-long vacation, but has no other State A contacts. Defendant answer, denying all allegations. 1 week later, defendant filed an amended answer, denying all allegations and including defense of lack of personal jurisdiction. I don't think so, Tim. State A has a long-arm statute that permits personal jurisdiction to the constitutional limit. Defendants moved for an order dismissing the action based on personal jurisdiction. Should they move it? Nope. It's a little late now. No, because defendant waived the challenge to personal jurisdiction by failing to include it in the original answer. Yep, that's the answer. What? Federal Rule of Civil Procedure permits litigants to raise personal jurisdiction challenges for the first time in an answer that's amended as a matter of course. Yeah. A plaintiff filed a diversity action against a teacher in federal court in State A. The plaintiff alleged that the teacher failed to pay $5,000 due on a valid service contract. The teacher does not dispute that there was a contract, but did testify before the jury they paid the debt. The plaintiff also testified before the jury, claiming the teacher had never paid the debt pursuant to contract, and that the $8,500 the teacher paid was for a rare automobile that the plaintiff had previously sold. Immediately after close of evidence, the judge sent the case to jury. The jury quickly returned a verdict for the plaintiff, in which judgment was entered. 5 months later, while in a coffee shop, the teacher's attorney heard two men speaking. The teacher's attorney realized they had been jurors at the teacher's trial and heard one of the jurors say to the other, "There's no way I would have ever found for that plaintiff teacher I couldn't stand the lawyer." All right, so we want to use the statements from the jury we overheard at a coffee shop to attack the verdict. How do you think that's going to work out, guys? And there's a course of action available to reverse the judgment. Not a chance in this world. No, because the time to file appeal has passed. No, because the teacher's attorney never filed a motion as a judgment of matter of law. Yes, because an attorney may file a motion for a new trial. Yes, because an attorney may file a motion for relief of judgment. I guess D. You can file the motion. It's just not going to work. Yeah. Evidence the jurors disregard the judge's instructions, so you want to try to permeate the jury? Woof. Woof. Okay, good luck with that. A grantor conveyed a commercial property to a friend so long as alcoholic beverages are not sold on the property. And if alcoholic beverages are sold on the property, the estate is to end at once. The friend took possession of the property. 4 years later, the friend opened a tavern and sold alcoholic beverages on the property. 6 months after the opening, while friend continued to operate the tavern, the municipality in which the property is located validly condemned the property. There are no applicable statutes. To whom should the condemnation proceedings be paid? To the friend and the grantor in equal shares because they both had an interest in the property. To the friend because he was in valid possession on the day of the condemnation. To the friend because the limitation is an invalid restraint for the sale of alcohol. To grantor because the friend's estate had ended. He was in possession on the day of the condemnation. That's the problem, right? Like, he was still in possession, so it should go back to him, right? No? To grantor because the estate had ended? Okay. I guess. A man and a woman were competing in an illegal drag race. Both of them were driving over the speed limit, but were otherwise driving very carefully. However, when a tire on the woman's car suddenly blew out, she lost control and crashed, injuring a pedestrian. The pedestrian later sued the man because the woman had no insurance or assets. Will the pedestrian prevail? Yeah. No, because the man did not cause the injury. No, because the man was driving very carefully. Yes, because the man and woman were acting in concert in a dangerous activity. There you go. On March the 1st, a seller orally agreed to sell his land, homestead, to a buyer for $4,600 to be paid on March the 31st. The buyer orally agreed to pay $2,500 on the purchase price to a creditor of the seller in satisfaction of a debt to which the seller had promised. On May the 10th, the buyer dictated his agreement to his secretary, but it omitted all reference to the payment of $2,500 to the creditor. In typing the agreement, the secretary mistakenly typed $4,500 rather than $46,000. Neither buyer nor seller carefully read the writing before signing. Neither noticed the error in price, and neither raised any questions concerning omission of it to the creditor. Excuse me. A buyer refuses to pay more than $45,000 for homestead. An action by a seller against the buyer for the additional $1,000. It would be the seller's advantage to prove that. The writing was intended only as a sham. The writing was a partial integration. There was a mistake in integration. There you go. There was a misunderstanding between seller and buyer concerning the purchase price. No, the problem is that there's a mistake in the integration. Shaking my head, always read. Yeah, probably doing my best, which is, arguable in terms of how good that is, but yeah. An investor from State A filed action in State B stockbroker in federal court in State A. The summons and the complaint were served in the office, where the process server handed the documents to an administrative assistant. You can't do that. You can't do that. The stockbroker has answered the complaint, answering a defense of improper service of process. Assume both state requirements and federal requirements are identical. Is the court likely to dismiss for improper service of process? No, because service was made on a person of suitable age found at the place of employment. No, because they waived the claim for improper service of process by asserting it in an answer. Yes, because an individual defendant may not be served by delivering process to a third party found at the defendant's place of employment. Yes, because the process of State A courts is not effective in State B. C is the right answer, and I don't think it's waived. Yeah. So yeah, improper service. I'm seriously tempted to get that YouTube play button rug we saw the other day and put it over here so we get the play button rug. I can't decide if that's a great idea or the worst idea ever. So yesterday, or the day, whatever it was at this point, we were looking to get friends for the play button. And what kind of merch is available on play button merch? And we uncovered some valuable things. The YouTube cookie cutter's pretty badass. I'm definitely buying one for my mom. We found the play button bed quilt and pillows, so we have some play button bed sheeting. And also we found a neon sign that was pretty badass. And also, pertinent to this discussion, a YouTube play button rug. And there's this empty space right here where you can see my floor. This space could be filled with something. For example, it could be filled with a play button rug. And I can't decide if this is the greatest idea or the worst idea I've ever had. With the play button rug. I can't decide if this is the best idea or worst idea I've ever had. I'll ponder it some more. A plaintiff has sued his insurance company for full loss of banquet hall by fire. The insurance company defended under provision of the policy limiting liability to 50% if flammable materials not essential to operation of the business were stored in the premises and caused the fire. The insurance company called the keeper of the city's fire inspection records to identify a report prepared and fired by the fire marshal as required by law, indicating shortly before the fire marshal cited the plan for storing gasoline at the banquet hall. Is the report admissible? Sure. The play button would really tie the room together. I'm picking up what you're laying down. I'm picking up what you're laying down. The rug is also expensive. It's somewhere between $150 and $250, depending on what size of rug I get. $9.99, the greatest idea? No, because it's hearsay, not with any exception. No, because the proceeding is civil rather than criminal. Yes, as public records describing matters observed to which there was a duty to report. That'd be the one. Yes, C. You don't think the rug would be visible enough? Oh, I'm sure it would pop. I'm sure it would pop. No problem. Or we could do a rug that would be more themed. We could do a rug that would have like Lady Justice on it. That would be cool. Like Scales of Justice, maybe? That might be cool as a rug. That'd be like more brand appropriate. So we could do something like that. That'd be cool. The play button I can't imagine is moving. Ever. The play button is definitely living where it's living forever. I love it too much. It's sitting right next to my license to practice before the U.S. Supreme Court, and like it's a way for me to flex on all the haters. These are ways for me to flex on the haters. Lady Justice sounds cool. Yeah. I might do that. Or I wonder if I could get like a suitable Lady Justice painting and put it on the door of the cabinet. That might work too. These are some ideas. Let's read this problem. A homeowner and a contractor entered into a contract for construction of a home for $300,000. The contractor was to earn a profit of $10,000 for the job. After the contractor had spent $45,000 in labor and materials, including $5,000 in oak flooring not yet installed, the homeowner informed the contractor the homeowner had lost his job and could not pay for his services. The homeowner told the contractor to stop working immediately. The reasonable market value of the labor and materials provided by the contractor at that point, including the flooring, was $40,000. The contractor used the oak flooring on another job. In action by a contractor against the homeowner for damages, which of the following will be the largest amount recoverable? $40,000, the reasonable value of the services the contractor had provided. $45,000, the contractor's construction costs. $50,000, the contractor's construction costs of $45,000, plus the $10,000 profit minus $5,000 saved by reusing the flooring, or $5,500 as a result of all that. So the costs minus his reasonable expectations minus his recovery. C is the correct answer. Thank you very much. So the certificate is my Desert Eagle. I could get a custom rug that says Sun Civilians. That's also a pretty decent idea. Yeah. I want to state this, by the way, for the record. Because there apparently was massive misunderstanding on this issue last night on Stephanie's stream, and in terms of what I was trying to do, and people misperceived it, and it wasn't appreciated, and so I want to make this clear. I was attempting, and apparently failing, but I was attempting to just be playful. Like a little light roasting, basically, right? I wasn't trying to actually be demeaning, although it appears that the overwhelming consensus is I came off that way. And so whatever attempt at humor I was trying was not working, which is my fault, right? If I'm going to try to be a comedian, it's, I need to make sure that it's working for the audience. And if it's not working for the audience on some level, I as a comedian am failing, right? And so that's my fault. But I was not trying to, in fact, demean Stephanie. I wouldn't do that. Stephanie has been an incredibly valuable person to this channel. I wouldn't go on her channel and do anything that would either hurt her personally or hurt her channel. Either way would be disrespectful. And so my intent was just to be playful. And I thought, at least in my own head, which maybe is my problem on reading the room properly, but I thought in my own head that that it was working, and apparently not. And so I feel really, this is one of the reasons, by the way, I'm in bad spirits this morning, because I realized I hurt somebody that I cared about, right? I was trying to do something that was fun and jovial and just trying to, prod for the sake of like having some fun and stuff like that. But it was perceived as not that. And so I have hurt someone I care about, and I feel really bad about that. And so, I take responsibility for that, because it's my responsibility, to try to make sure I'm reading the room correctly, which apparently I was not doing. And apparently the overwhelming consensus was from people who were messaging Stephanie asking if she was okay, because people thought I was genuinely insulting her or thought I was genuinely hurting her. So to the extent that I was trying to convey a joke, the joke was not conveyed. And it led to problems. And I feel really, really bad about that. And I've tried to communicate that to everyone. It was also perceived that way by Stephanie, as I've later learned. Like, I didn't perceive that at the time. Right? I didn't perceive there was a problem at the time. So maybe I was just misreading her reactions. But, so it was hurtful. I mean, it was hurtful to Stephanie. And I felt really, really bad about that. And so that's one of the reasons I'm down. Because I made a misstep. Hold on one second while I check this text message, if my phone will ever respond. Okay. I made a misstep in two different ways, right? I hurt her personally, and also I did it in the context of her channel. And both of those are really problematic, right? I believe that every creator should be able to run their channel the way they want. And if I misstep in a way that is not what that creator wants on their channel, then if I misstep in a way that that creator doesn't like for their channel, then to some degree they can't be wrong, right? If the issue is the creator of that channel doesn't like what I'm doing, to some degree they can't be wrong, because it's their channel, right? I suppose there is some idea of them being unreasonable as sort of like an outset idea, maybe. But like, your default is basically that they can't be wrong. So because it's their channel and they have the right to kind of run their house the way they want to, right? So it's like going over to someone's house and you behaving in a way they don't like. So basically, as your kind of default proposition, they have the right to run their house the way they want. Now, I suppose in some sense there's some sort of outside where that's completely unreasonable and where you're like, well, that guy's just a jerk. But your default is that they are in control of their house and in control of their channel. So to the degree that the creator of the channel is not perceiving or enjoying what I'm doing, or that I'm harming their channel, that's wrong. And I shouldn't do that. I can do kind of anything I want on my channel because it's my house. If I go into other people's houses, I have to respect what they want or don't want. And to the extent that I misstep, that's a problem. And, that's something that, so that's number one. Because I don't want people coming into my channel, whether it's in my chat or on the live stream, I don't want people coming into my chat and doing things that I don't want, right? And so I'm kind of in control of what that is. And maybe there's some sort of outside idea of unreasonableness, but basically your default is I get to control that, right? And then, so that's the one. And then two, obviously, of course, Stephanie is also a friend. she's someone I care about and respect, and I hurt her on a personal level. So that's two. So the way I see it, basically, there's two major sins here. Because, of course, sin means missing the target, and I missed the target. And so I feel really, really bad about it. And I'm trying to have a conversation with her about it as well, privately as well. And so I'm trying to talk with her about it as well, and deal with that with her as well on a personal level. So I'm talking with her and trying to do all that. But I figured, as long as we're here and having a discussion, I could apologize and be like, yeah, I made a mistake. I made a misstep. I thought everyone was having a good time, and it wasn't the case. And so I made a mistake. So a defendant was indicted for the murder of a victim by poison. At trial, the prosecutor calls the county coroner, who is a board-certified pathologist, to testify that, in accordance with good practice in her specialty, she has studied slides made under the supervision by medical assistants of tissue taken from the victim's corpse, and in the coroner's opinion, based on that study, the victim died of poisoning. The slides themselves have not been offered as evidence. The coroner's opinion should be admitted. Should it be excluded because the cause of death is a critical issue to be decided by the jury? Nope. Excluded because opinions based on facts, not on evidence? Nope. Admitted because the coroner followed accepted medical practice in arriving at her opinion? Sounds very promising. Admitted because her opinion is based on matters observed pursuant to duty imposed by law. Well, that may be true, but even if she fucks it up, you might have a problem. So C is the better answer. It's following the medical practice. Yeah, that's a better answer. I don't like hurting my friends. One of the things as a creator I'm working on, and still not perfect at by any means, but one of the things I'm working on as a creator is trying to figure out whose voices to consider and whose voices to care about. Because you can't please everybody, and trying to will absolutely drive you insane. And it has been remarked, and I think correctly so, that I tend to be oversensitive. I tend to be overreactive to people in chat. This is detrimental for my own mental health, among other reasons. So, one of the things I'm learning and still working on and still learning is trying to exclude voices and trying not to care about what certain people think in terms of what they think about what I do. So, to the extent I overreact to certain people's feelings because they're just, strangers to me, that, of course, doesn't hold to my friends. So while it is good for me to continue learning to exclude the critiques and criticisms of the chat, because trying to answer their critiques and criticisms would absolutely drive me insane, I don't want to ever reach the position where I'm doing that for my friends. So to some degree, it is good for me to not care about what people in general think, but it is necessary for me to care about my friends. And so I hurt my friend and I feel bad. you know, answering the critiques of everyone will cause you a psychotic break. Yeah. The problem, at least for me, is it's just too many voices in my head. That I don't know that other people might have problems with it for other reasons, but like there's only so many voices I can have in my head, and for me it's like just having too many voices in my head is just there's a limit to how many voices I can have in my head at once, and taking people's feedback into consideration is adding another voice in my head, and whatever the number is, at some point it just absolutely drives me crazy. Because like, how many different voices can I have in my head at once without going insane? Right? So how many? There's a problem. A customer went into a store at approximately 6:45 p.m. to look at some suits. The customer selected 3 suits from the rack and went to a dressing room to try them on. Signs posted, what time is it? 12 o'clock? I have an appointment at 1, so we've got about a half hour more before I have to leave. Maybe 25 minutes, we'll see. That doesn't matter. It's all fine. Yeah. Yeah. Tell the voices no. Well, you do understand what I mean by voices, right? You understand what I mean by voices. There are different kinds of voices in my head. You understand what I mean. Like, you're taking people's advice, or you're taking their thoughts into consideration. When you take someone's thoughts into consideration, you're in some sense, take their voice is now in your head. Because like you now are like, you're taking into, if you listen to somebody and you're considering what they're saying, their voice is now in your head, right? So that's kind of what I mean by that, right? It's like if you're listening to someone and you're considering what they're saying, their voice is now in your head. And so it's like, well, how many people's voice can you have in your head at once before it drives you crazy? So these are different kinds of voices, not psychiatric voices. Although, yeah. I am critical of myself, that's true. I can get down on myself. Internalizing voices of others is legitimately a non-psychological thing. Yeah, exactly. It's like, well, if I'm really gonna listen to you, I've got to internalize it on some level. It's like unavoidable, right? It's like, isn't that what it means to listen to somebody? It's like really internalizing it. I mean, yeah. A customer went to a store at approximately 6:45 to look at some suits. Okay. The signs on the wall of the store stated the closing time is 9 o'clock. However, because of special awards banquet for employees, the store was closed at 7 o'clock. When the customer emerged from the dressing room a few minutes after 7, he was alone and locked in. The customer tried the front door, but was secured on the outside by a bar and padlock, so he went to the rear door. The customer grabbed the doorknob and vigorously shook the door. This activity set up a mechanism that sprayed a chemical mist at the customer's face, causing him to be temporarily blind. If the customer is to prevail on a claim against the store based on battery from the use of the chemical spray, the customer must establish that he suffered bodily harm, the spray mist was offensive or harmful, he suffered emotional distress, his conduct was not a facial cause of the chemical spraying him. It's offensive and harmful is the standard. Yeah. That's pretty bad. A landowner contracted in a signed writing to sell Greenacre, a 500-acre tract of farmland, to a farmer. The contract provided for exchange of deed and purchase price of $500,000 in cash on January the 15th. Possession was to be given to the farmer on the same date. On January 15th, the landowner notified farmer that because the tenant of Greenacre lawfully refused to quit the premises until January the 30th, the landowner would be unable to deliver possession until then, but assured the farmer that he would tender the deed in possession on that date. Throughout the month of January, the market value of the property was $510,000 and its fair monthly rent was $5,000. On January the 30th, the farmer accepted conveyance and possession of Greenacre and paid the $500,000 purchase price, but notified landowner he was reserving any rights he might have to damages caused by breach. The farm owner intended to use the land for raising cattle and entered into a contract for the purchase of 500 head of cattle to be delivered to Greenacre on January the 15th. Because he did not possess Greenacre on that date, he had to rent another pasture at a cost of $2,000 to graze the cattle for 15 days. The landowner had no reason to know the farmer intended to use Greenacre for raising cattle or that he was purchasing cattle to be grazed. Okay, so he doesn't know, so that's going to be a problem when it comes to some kind of damages, which I'm sure the problem will tell me about. In action by farmer against landowner, the farmer is entitled to recover nothing. Because he paid the purchase price on January 30th, he waives whatever cause of action he might have had. You know that's wrong. Nominal damages only because the market value of the land exceeded the contract price. $2,500 only, the fair rental value of Greenacre for 15 days. $2,500, the fair rental value of Greenacre for 15 days, plus $2,000. Yeah, so since you didn't know about that, like, these damages have to be known to both parties. Consequential damages, this is what we're looking for. That was the name I was looking for. This is going to consequential damages. In order to get consequential damages, they have to be foreseeable to both parties. So, for example, the need to rent another piece of property is probably foreseeable, but not so much for the grazing fee. So probably $2,500. Yeah, that's right. Yeah, consequential. Yeah, this is the right answer. This is the rule. Consequential damages for a breach are limited to those the breaching party had a reason to foresee. You have to be able to foresee it. So if he knew about if he knew about the cattle, he knew about all that would be one thing, but he didn't know. No, so he can only be held liable for what was reasonably foreseeable in consequential damages. That is the right answer. A mother owned Blackacre, a piece of property where every bad thing happens. A 2-family apartment house on a small city lot not suitable for partition in kind. Ooh, I could get a Texas rug though. Oh, I like that idea though. Because I have the Texas flag on my wall, and there's not really a good place to put it on my floor. I could get a Texas flag rug. Maybe I could get a Texas flag rug with the scales of justice on it. Oh, that's a good idea. I like this idea. This is promising. A Texas flag rug with the scales of justice on it. Ooh, this sounds promising. All right, where was I? A mother-owned Blackacre, a 2-family apartment house on a small city not suitable for a partition in kind. Upon mother's death, the will devised Blackacre to my son and daughter. A week ago, a creditor obtained a money judgment against the son and property filed in the judgment in county where Blackacre is located. A statute in the jurisdiction provides any judgment properly filed shall, for 10 years of filing, be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. The son needed cash, but the daughter did not wish to sell Blackacre. The son commenced a partition action against judgment and the creditor. Assume the court properly ordered a partition by judicial sale. After the sale, the creditor's judgment will be a lien on only the portion of the proceeds of the sale due to the brother, right? Because he has the that's the answer. Yeah. I need to get that Texas metal flag thing again and put it on my cabinet. That'd be good. That'd be good. I need to probably do that. That'd be good. Or a big ass Texas fridge magnet. That'd be kick ass. Suspecting a defendant had slain his wife, police detectives persuaded one of the defendant's employees to remove a drinking glass from the defendant's office so it could be matched for fingerprints. Comparison with a knife found by the body. The fingerprints matched. The prosecutor announced that he'd be presenting comparisons and evidence to the grand jury. Defendant's lawyer immediately filed a motion to suppress evidence of the fingerprint comparisons to bar consideration by a grand jury, contending the evidence was illegally acquired. Ooh. The motion should be granted because if there's no probable cause, the grand jury should not consider the evidence. Granted because the employee was acting as a police agent and seizure of the glass without warrant was unconstitutional. Denied because the motion based on exclusionary rule are premature in a grand jury proceedings. That's the right answer. Denied because the glass was removed by possession of a private citizen, not police officer. It's premature. Yeah. You should make a latch hook rug. Then you can do any design you like. It's quick to make. What is a latch hook rug? Let's take a look. Oh, this requires, like, me to construct something? Oh, I don't know, man. A storekeeper who owns a large hardwood store sells power saws for both personal and commercial use. He often takes older power saws as trade-ins on newer ones. The older power saws are then completely disassembled and rebuilt with new bearings by the storekeeper's employees and sold by the storekeepers as reconditioned saws. A purchaser, the owner and operator of a cabinet-making shop, informed the storekeeper he wanted to buy reconditioned circular saw for use in his cabinet-making business. However, the blade was on the saw he picked out had very coarse teeth for cutting rough lumber. The purchaser told the storekeeper they wanted a saw blade that would cut plywood. The storekeeper exchanged the coarse blade for a new one with finer teeth that would cut plywood smoothly. The new blade was manufactured by Saw Blade Company, which used all available techniques to inspect its products for defects. The reconditioned saw had been manufactured by Power Saw Company. The week after the saw was purchased, the employee who works for purchaser in the purchaser cabinet making shop was injured while using the saw. The employee's arm was severely cut. As a result, the cabinet making shop was shut down for a week until a replacement for the employee could be found. If the employee was cutting a sheet of hard plastic, and while doing so, the saw blade flew to pieces and severely cut the employee's arm, and if the employee asserts a claim based on strict liability, not so much. The defense most likely to prevail is the employee did not purchase the saw blade. The blade was being put to improper use. There you go. The employee was contributorily negligent. Saw Blade Company used every available means. Improper use is the right answer. A homeowner met a man who was known to him to be a burglar in a bar. The homeowner told the man that he needed money. He promised to pay the man $500 if the man would go to the homeowner's house the following night and take some silverware. The homeowner explained to the man although the silverware was legally his wife would object to his selling it. The homeowner pointed to his home, one of a group of similar tract houses. He drew a floor plan of the house that showed the location of the silverware. Homer said that his wife usually took several sleeping pills before retiring, and that he needed to make sure that she took them the next night. He promised to keep a window unlocked. Everything went according to plan, except that the man, deceived by the similarity of tract houses, went into the wrong house. Ooh. He found a window unlocked, climbed in, and found silver where the homeowner had indicated. He took the silver to a cocktail lounge where the payoff was to take place. At that point, the police arrested the two men. If the homeowner and the man are charged with conspiracy to commit burglary, the best argument for acquittal is no burglary. It was his stuff. First of all, it's not trespass because he's given permission to enter. Second of all, it's not stealing because it's his things. So there's no conspiracy to commit burglary. Insurance fraud, but not the burglary, right? The best argument is the man was the alter ego of the homeowner. Ooh, exciting. They did not intend to commit burglary. Yeah, there's no burglary. No trespass, no theft. A bank sued a student in federal court alleging the student failed to repay a loan that came due on March the 1st, 2020. The student answered the bank's complaint, denying liability and raising payment of loan as an affirmative defense. The student then moved for summary judgment and supported his motion with his own affidavit and the affidavit of 4 eyewitnesses. Each eyewitness stated the student repaid the bank in full, in cash, on May the 1st, at a meeting involving the bank, the student, and the 4 eyewitnesses. What action should the bank take to ensure trial by jury? Offering evidence that challenges the student affidavit on the grounds they were made without personal knowledge. Since they were there, that'd be a little bit hard. Offering evidence that raises a material issue of fact relating to the accuracy of the affidavits by showing a reasonable jury could find for the bank. That would be helpful. Not offer evidence in opposition to the summary judgment motion and demand a judgment based on the existence of genuine issue of material fact. No. Not offer evidence in opposition to the summary judgment and demand jury based on insufficient evidence. No. You would need to raise an issue of material fact. That would be super helpful. Okay, moving on. Yeah, unindicted counsel is not burglary because he would have the trespass, but he wouldn't have intent to commit theft therein. So, like, his mistake, well, I'm not even sure he would have trespass because mistake of fact. The mistake of fact might be enough to avoid the trespass on the criminal charge. So I'm not sure he even has trespass, but he would civilly, obviously, but I'm not sure about criminally. So anyways, pressing on, doesn't matter. A worker was injured when a machine he was using on a job malfunctioned. The worker brought a federal diversity action against both the machine's manufacturer and the company responsible for the machine's maintenance. At trial, the worker submitted a proposed jury instruction on negligence. The court did not accept the proposed instruction, instead gave a negligence instruction the worker's attorney believed was favorable and legally incorrect. The attorney did not object before it's given. Well, that's a problem. The jury returned a verdict for defendant. The workers moved for a new trial on grounds the court's negligence instruction was improper. What argument has the best chance of persuading the court? Issues of law can be raised at any time. The court's negligence instruction was incorrect and the worker's objection was preserved. I don't think so. The court's negligence instruction was plain error. There you go. All right, he didn't preserve the issue. So your only way is plain error. An employee worked for a daycare center run by Happy Face Daycare Corporation. At center, one of the young children often arrived with bruises and welts on his backs and legs. A statute in the jurisdiction requires all daycare workers to report to police cases where there's probable cause to suspect child abuse, and provides for immediate removal of the home of any suspected child abuse victims. The employee is not aware of the statute. Well, that's a real problem. Nevertheless, he did report the child's condition to his supervisor, who advised him to keep quiet about it, so the daycare center would not get into trouble for defaming a parent. About 2 weeks after the employee first noted the child's condition, the child was beaten to death by his father. The employee's been charged with murder. No, murder's not going to work. The employee's been charged with murder in the death of a child. The evidence at trial disclosed in addition to the above. The child had been the victim of beatings by father for some time, and these earlier beatings had been responsible for the marks that the employee had seen. The child's mother had been aware of the beatings but not stopped them because she herself was afraid of the child's father. The best argument that he's not guilty of murder is he was not aware of the duty to report statute. No. He lacked mental state to commit crime. Sounds very promising because murder is a specific intent crime. His omission was not proximate cause of death. The daycare corporation rather than employee was guilty of the omission, which was sanctioned. No, the mental state is going to be the issue. Yeah. If your children's daycare is named Happy Face Daycare Company, you might want to consider other daycare options. I'm just, Yeah. In diversity action in a federal court, the plaintiff seeks to have a drug abuse counselor from an employee assistance program testify about her communications with the defendant. The communications are privileged against disclosure under relevant law of the state where the plaintiff's cause of action arose. What should govern the court's determination of admissibility of the counselor's testimony? Federal common law is interpreted by light of reason and experience. Federal statutory law, the court's sound instruction in interest of justice, or state's privilege law. Well, the issue is it common law or statutory? I'm going to say it's common law. Is it D? State law governs privileges relating claim or defense for which state law applies. Okay. It's just a federal rule of evidence that says that. A federal court studying diversity should look to the host state's choice of law rules when deciding whether privilege law applies. Because it was based in diversity. That was the key aspect of it. Yeah, that was the key aspect. It was based in diversity. Yeah. Two friends planned to incorporate a business together and agreed that they would own all the corporation stock in equal proportion. A businesswoman conveyed a land by warranty deed to the corporation and successor and assignees. The deed was recorded. Thereafter, the friends had disagreement. No papers were ever filed to incorporate the business. There's no applicable statute. Who owns the land? The businessman, because the deed was warranty deed. The businesswoman, because the deed was void. The two friends as tenants in common. Sounds promising. Because they intended to own the corporation stock in equal proportion. The two friends as tenants in common because they were intended sole shareholders. D. B. It's void. The corporation not been legally formed. Okay. I think this will be the last question. He plaintiff sued a defendant, alleging that she was seriously injured when defendant ran a red light and struck her while she was walking a crosswalk. During defendant's case, a witness testified the plaintiff had told him that she was barely touched by defendant's car. On cross-examination, should the court allow the plaintiff to elicit from the witness the fact that he's an adjuster for an insurance company? No. Not really. I mean, no. No, because the testimony about liability insurance is barred by rules of evidence. That's not where we're trying to go with this. No, because reference to insurance raises collateral issue. That's also not where we're trying to go. Yes, it's a substantive and impeachment. Yes, for impeachment only. I say substance and impeachment. It's a statement by a party opponent. A statement against interest. No. It's legitimate grounds for bias, but inadmissible substantive evidence. Okay, let's see. Yeah, I don't think the way the question was phrased, I'm not 100% sure about the answer on that one. All right, so how do we do now? Well, we have picked up our average, my friends. We have picked up our average. For the day, we are now at 73 questions answered, with an overall percentage of 64.4. which is more in line with my overall stats. So we have picked up ground from this morning and more in line with my overall average. So, yay. Good times. I think I'll be fine on the exam. I really do. The only issues will be my mood during the day and how tired I am in the morning, because someone decided the bar exam should be in the morning, which is annoying. But, if we're hitting 65% on these questions, we would expect to do a little bit better on the bar exam than we're hitting here. We would expect to do a little bit better, so we're well in threshold of passing, I think. Well, my friends, I have to leave because I have an appointment I have to go to in person. But I appreciate everyone here, and we will probably be back on with more stuff later. Thank you, Lady Autumn Scott. It's really, really nice of you. I appreciate it. What time in the morning? I don't know. Is it like 9 or some bullshit? I don't even know what time the bar exam is. I probably should know. Let me find out real fast. What bullshit time do I have to show up for this thing? Let's see. Instructions begin at 8:30 in the morning. Is coffee served during the exam? No. I'm not allowed to bring in coffee. All I can bring in is water. Not even allowed to bring in coffee, man. Bullshit. It's 3 hours in the morning, 3 hours in the afternoon, both Tuesday and Wednesday. So it's 6 hours. So it's 12 hours. All right, I gotta go. I'll talk to you guys later. Bye.